Senate Committee on Criminal Justice will come to order. Clerk will call the roll.
Chair Flores,
Present.
Vice Chair Parker, Senator Hinojosa,
Present.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu.
The quorum is not present, but we will continue with our business and laying out some bills. The purpose of today's hearing is to take up and consider items related to sexual assault and human trafficking, better protection of victims, and enhanced penalties for certain crimes. The legislation on our agenda this morning seeks to protect Texans who fall victim to criminals who are using counterfeit notary seals to steal their homes, to victimize our citizens in horrible sex-based human trafficking operations, to give law enforcement new tools to stop gasoline thefts, and to address issues with our most sexually violent predators who are receiving inpatient treatment. Additional training for jailers who interact with veterans requires interpreters for defendants in criminal proceedings and sets new standards for public disclosure of law enforcement personnel files and deadly conduct for police discharging their official duties. The goal of these bills is to improve public safety and how our criminal justice system functions, to ensure the Lone Star State protects its citizens from excesses and duplicity at a time when rising crime is one of the top issues of all of our constituents. This committee stands firm in its desire to improve what is not working to make our state a better place for all Texans. It is the intent of the chair to lay out the bills one at a time and to take invited and public testimony, then vote on each bill in the order of presentation, provided we have a quorum. There's a lot of committees going on this morning, and so people will be coming in and out. But we'll do the best we can to do our business today. If you intend to provide verbal testimony or would like to register a position on one or more of these bills, please register at one of the kiosks located behind the committee hearing room, and testimony will be limited to invited testimony and public testimony. Public testimony will be limited to 2 minutes per witnesses or as the direction of the chair. So members, anyone have any statements you wish to make before we proceed? So the chair calls up Senate Bill 1537 and recognizes Senator Zaffarini.
Thank you, Mr. Chairman. Mr. Chairman and members, Senate Bill 1537 relates to the appointment of an interpreter in a criminal proceeding. Members, this is a cleanup bill for the Code of Criminal Procedure, and it is part of the legislative agenda for the Texas Access to Justice Commission, of which I am a member. Unlike the government code, the Code of Criminal Procedure does not require interpreters to be licensed or certified, stating only that, quote, any person may be appointed to interpret. By contrast, the government code requires courts to appoint licensed court interpreters in both civil and criminal cases, except under specific circumstances. Due to the lack of explicit reference to these minimum requirements, some courts inconsistently apply them in criminal cases, leading to uncertainty and inconsistent enforcement, despite case law affirming that courts in criminal cases must adhere to the government code standards. Generally, then, Senate Bill 1537 would clean up the language of the Code of Criminal Procedure by first replacing sworn in with a clearer term, appointed, to reflect the terminology used in the government code, and second, explicitly referencing the interpreter appointment requirements in the government code to ensure consistency between the two statutes. There is a committee substitute, Mr. Chairman, that is simply the Legislative Council version.
So we will leave this pending?
Yes, sir.
So remember, are there any questions? Hearing none, invited testimony on Senate Bill 1537 is now open. Is Ms. Jennings here for? Okay, would you wish to call your witness up? No? Thank you. Thank you for being here. So members, any questions of this witness? None. Hearing none, invited testimony is closed. Seeing no other invited witnesses, the chair closes invited testimony. The chair now opens public testimony. The chair calls the following witnesses. We see no witnesses and no one registered of public testimony. Is there anyone here on, for, or against Senate Bill 1537 that wishes to speak publicly? Hearing none, public testimony is closed. And we will hold this bill pending.
Thank you, Mr. Chairman and members.
Chair calls up Senate Bill 993. Senator Nichols, you're recognized.
Thank you, Mr. Chairman and members. Senate Bill 993 authorizes peace officers with the Comptroller's Criminal Investigative Division to apply directly to a district court for a warrant to install and use mobile tracking devices. The investigative division is responsible for enforcing state tax laws and preventing tax fraud, including motor fuel theft. These crimes often involve organized schemes where fuel is stolen, transported, and resold illegally. Mobile tracking devices help law enforcement monitor suspect vehicles and pinpoint the locations where these illegal activities occur. Under current law, the investigative division officers are not authorized to apply for these warrants on their own and must rely on other local and state law enforcement agencies to do so on their behalf. This creates delays and burdens with other agencies. It adds additional work and can weaken the warrant applications since CID officers are the subject matter experts in these complex cases. By granting these officers the authority to apply for tracking device warrants directly, this bill streamlines investigations, preserves valuable law enforcement resources, ensures stronger, more informed applications are presented to the court. We have a Lieutenant Brett Froh with the Comptroller's Criminal Investigative Division is here as a resource to answer any questions.
Members, any questions? Senator Hinojosa.
Thank you, Mr. Chairman. And you know, Senator Nichols, I really like your bill. It's really a serious issue and problem we're having with fuel theft and fuel depots, but not only along the border, but also in
My district.
in your district and other parts of the state where we have a large production of oil and gas. And many of these vehicles, it's very unfortunate, but sometimes the law enforcement comptroller's office, for example, is unable to detect where they are and trace them just because of the lack of authority to be able to get a warrant. So, got a good bill.
Thank you, sir. I agree.
Any other questions? The chair now opens for invited witnesses. Lieutenant Brett Froh. Chair calls Lieutenant Brett Froh. Is he here? Are you here? Would you wish to? Any questions for the lieutenant? Thank you for being here. So, having no more invited testimony is closed. Chair now opens the floor for public testimony. There is no one registered. Is anyone here to testify on, for, or against Senate Bill 993? Hearing none. Public testimony is closed.
Thank you, Mr. Chair.
And since we don't have a quorum here, we'll hold pending. Chair calls up Senate Bill 693 and recognizes Senator West. And Senator West offers a committee substitute for Senate Bill 693. Is there any objection to considering the committee substitute for Senate Bill 693? Hearing none, so ordered. I recognize Senator West to explain his committee substitute for Senate Bill 693.
Thank you very much, Mr. Chairman and members. Members, one of the most critical issues in this legislative session is preventing deed fraud. Deed fraud is when someone, through various fraudulent means, steals another person's real property through forged or fraudulent documents filed in the real property records of the county clerk. One major way to fight deed fraud is to fight notary fraud. In terms of the committee substitute, Mr. Chairman, these are the changes that are being made. The committee substitute creates a criminal offense for notarization for a person not personally appearing. Under this proposed statute, a person commits an offense if, as a notary public, the person performs a notarization with the knowledge that the signer, grantor, maker, or principal for whom the notarization is performed did not personally appear before the notary public at the time the notarization was executed. This offense is a Class A misdemeanor unless the document executed involved the transfer of real property, in which case it's a state jail felony. Additionally, because of the sophisticated nature of identity fraud in modern times, the bill creates an affirmative defense for notary publics who are tricked by persons who personally appear for them and present apparently valid proof of identification. Further, the bill creates a continuing education requirement for notary publics, and that the Secretary of State office is charged with preparing and promulgating that particular training. The bill further requires notary publics will be required to take a continuing education requirement before being reappointed to their commission. The bill also stipulates that new notary publics must take the training. The bill stipulates that notary publics renewing their commission may not be required to take more than 2 hours of continuing training. That's what the bill does.
Any questions for Senator West? Any questions?
I have one resource witness, Your Honor. Mr. Chairman.
I guess I do have a quick question.
Senator Hinojosa, you're recognized.
I guess the way it is, under present law, a person has to appear in person before a notary to be.
Right, they're supposed to, right?
So they cannot notarize and then have the person come in later and sign the document.
Right.
Thank you.
It's supposed to be contemporaneous.
And that's a Class A misdemeanor.
Class A misdemeanor.
So the chair now calls up invited witnesses. Philip Clark, Assistant District Attorney, Dallas County. Thank you for taking the time to come down and travel, come see us. State your name and who you represent, and proceed with whatever you have to say about the bill.
Certainly, and thank you for having me, Chairman Flores. Good morning, members of the committee. I thank you for having me here today to speak in favor of SB 693 as substituted. My name is Philip Clark. I'm an Assistant Criminal District Attorney for the Dallas County District Attorney's Office. I prosecute cases of real property theft. And I want to thank Senator West for filing this bill and this substitute, because our Texas records are not secure. And in too many instances, it has devastating effects. And it's all because the notary public has enabled a crime. I see firsthand in my cases how easy it is to steal someone's land or house. And I see how hard it is to investigate that theft and how long it can take a homeowner to get the title back in their name. And if this is new to you, let me tell you, it's mind-boggling. Not only that this happens, but it happens easily, and it happens often. In my county alone, scores of properties are stolen every year. Some are abandoned or dilapidated. Some are not. Some are inhabited. Some are multi-million-dollar properties. Some of the properties I've seen have been retail spaces, active, inactive, and some have been even apartment complexes. We see it all. Infamously, it happened last year to the Graceland Mansion in Memphis. Often these properties are sold cheap, and the unsuspecting buyer is then out, both the property that they bought and the money that they paid to the thief. And sometimes it's their last dollar. One of the victims in my cases was sued by the city for back taxes on the property, even though he had moved out of the property when he learned from the investigators that he didn't actually have clean title. It's like a crack in your windshield. These things can spider in many different unpredictable directions. We all know that our property records rely on notaries public to authenticate that the person signing a document is the person who they say they are. And a deed only needs one signature, the owners or the sellers. Most formally, they are the grantor in this scenario. I've seen over 300 real property theft cases, and in the vast majority of them, it comes down to the notarization. Most of the time, the notary was duped or just lax, and in about a quarter of those cases, the notary simply notarized a signature knowing that the person was not there in front of them. And in many cases, the notary either didn't make a record in their logbook or didn't keep their logbook. And as you can imagine, that makes it very difficult for investigators to work back on this and investigate the crime. This committee substitute is aimed at reducing these problems, making it harder to commit this crime and easier to investigate. I welcome any questions that you may have.
Any questions, members? Thank you very much for being here. We
Thank
appreciate
you.
your support of
I thank you for your favorable consideration, and thank you, Senator West.
Having no more invited witnesses on the list, invited witnesses is closed. Invited testimony is closed. So we now proceed to public testimony. The chair now opens for public testimony, and we have no one registered. Is anyone here on wish to testify on, for, or against committee substitute for Senate Bill 693? Hear none. Public testimony is closed. At this point, we will leave it pending, Senator. Chair calls up Senate Bill 1610 and recognizes Senator Perry. Senator Perry offers a committee substitute for Senate Bill 1610. There's no objection to considering the committee substitute for Senate Bill 1610. Hearing none, so ordered. I recognize Senator Perry to explain his committee substitute for Senate Bill 1610. There you go, sir.
There you go. Got it. Thank you, members. Mr. Chairman, Texas Civil Commitment Office operates a treatment and supervision facility for civilly committed sexually violent predators. TCCO has continued to encounter several challenges with problematic clients that regularly hinder the effectiveness of the agency's treatment and supervision programs. Senate Bill 1610 addresses facility safety and security, sex offender registration, and civil commitment process. In particular, the bill clarifies that civilly committed clients are subject to increased penalties for new felonies that are committed at the facilities, including assaults on a staff. In recent years, several staff has been seriously injured by some of the civilly committed clients. Violence of threats of violence must be stopped, and this bill ensures clients face stiff penalties for assaulting staff. Senate Bill 1610 also ensures that every client that is registered is a registered sex offender, a loophole in the law that had been prevented were several clients from having to be registered. The committee substitute has removed stiffer penalties from the bill. In the filed version, the clients were subject to life in prison without parole for the new felonies committed at the facility. This is no longer the case. Committee sub ensures TCCO clients are subject to parole if they commit new felonies. Filed version denied the parole, clarifies TCCO clients are subject to life to 25 to life if they commit a new felony. Filed version punished clients with life imprisonment for new felonies. Maintains current statute of limitations for TCCO clients who commit new felonies. Filed version had eliminated the statute of limitation for TCCO clients who commit new crimes. Ensure clients are eligible for community supervision. The filed version had denied community supervision, removes provisions about flying drones over the facility that's been held unconstitutional. So in a nutshell, we have a supervision and committee, a sexual violent predators treatment facility. They are committing violent assaults on the employees that work there. We are continuing to have a hard time keeping that facility staffed with those kind of instances. And this is a bill that says if you commit a crime while you're in treatment, you will go back to jail. That's what it does.
Thank
And I
you.
do have resource witnesses if anybody needs them.
Senators, any questions? Any questions? Nope.
Got it? Appreciate it.
Questions? Invited testimony for committee substitute Senate Bill 1610 is now open. The chair calls Jessica Marsh, Marsha McLean, and Haley Glisson. So we'll start on my right and state your name, who you represent, and proceed.
Marsha McLean, the Executive Director with TECO and represent the Texas Civil Commitment Office. We are all here basically as resources as far as this bill. I think Senator Perry laid it out very well. If anybody has any questions on the specific of it, let us know. We also have the facility administrator of the facility here that can talk to more about the assaults going on at the facility. And one of the things that's in this bill, I think, is crucial. We currently have a client up there that was convicted of murders, and he wasn't convicted of any sexual offenses, so he's not required to register. This bill will change that because there was a sexual component of his offense.
Thank you, Senator Hinojosa. You recognize.
Thank you, Mr. Chairman. And Marcia, I know we've been dealing with this issue for many, many years. Way back, I guess I was in the House at the time. What kind of issues are you encountering? I mean, this bill is fairly comprehensive, trying to deal with some of those problems and issues that you're having there at the civil commitment facilities. Could you elaborate on that a little bit?
What we've seen in the last year is a 22% increase in assaultive offenses. And there's some other sexual offenses going on up there that there hasn't been some immediate response to the behavior that's going on, and the clients are seeing that they can get away with several of the offenses that's going on.
Is this in the facilities?
This is inside the facility, yes. There's assaults on staff. There's new sexual activity going on either towards staff or other clients at this point. They're refusing to even get involved in treatment in certain areas. And we've just seen this in the last few years. Previously, that we didn't have a problem with that. The assaultive offenses has gone through the roof. The facility administrator was actually assaulted there, bitten by one of the clients who threatened to kill me because he was mad we closed the phones down when we were doing an investigation. This guy was 6'6", 350 pounds. So if you see the video and I'm standing by him, I look like a little ant right there at that point. But they've gotten emboldened, it seems, to have less good behavior while they're up there, and which involves them not getting involved in treatment and being able to move up and get out of the program, which is our goal.
So I guess in a sense, you're asking for extra tools to be able to manage some of this behavior from some of the sexual violent offenders?
Absolutely. And that these are serious consequences when they misbehave in a facility. All these guys have already been convicted of 2 sexually violent offenses. I would venture to say there's been more, but they have at least 2 convictions for that. They have a chance to get into a treatment program that's tiered where they could move up if they behave and internalize the treatment. But what we're seeing is they aren't behaving on some of these. Not all of them. We've got some that are doing okay. But the ones that aren't behaving, there's very little we can do with them.
Okay. Thank you.
Mr. Chair, I would add that we need to, and we're working through this, and we will talk with you and Chair Huffman on concurrent jurisdictions for SPUs. These guys are finding a way to where they don't end up being prosecuted for different reasons, and I won't go into a lot of detail, but the SPU unit may be an answer to effectively set that standard that there is consequences. And I think that's the follow-up, and we're looking at what an amendment might look like to add that concurrent jurisdiction after talking to stakeholders.
It would seem to me, thank you, Mr. Chairman, that you would also need some more resources on the prosecution side to be able to handle it.
SB 22 sought to rectify some of that, and it was available. It was not, let's just say it was not utilized to its fullest capacity. It should have been probably, but we will work through those. But concurrent jurisdiction where SPUs come in on the state's dime and can prosecute these in these different areas when that seems to be a stumbling block for whatever reason is something that I'm interested in, because that treatment facility has a valid purpose. It serves a state interest, but it can be really messed up by a few bad actors. So.
And actually, they asked for additional funding to increase because of the increase in the workload.
Yeah, and we granted them funding, but part of that funding was actually turned back to the state. So there's just different issues going on the local side that we need to look through. But I'm at a point where I think the SBU concurrent jurisdiction may be a real additive to this equation to fix what's going on out there in the facility.
Thank you, Mr. Chairman.
We look forward to working with you, Senator Perry, on this. And members, any other questions? Thank you all very much.
Thank you. Thanks, Senator.
Seeing no other invited witnesses on this bill, the chair closes invited testimony. Chair now opens public testimony. So the chair now calls the following witnesses: David Bowers and Alicia Castillo. Just as resource? Okay, thank you. Alicia Castillo. Welcome. Your name and who you represent and your position on the bill.
Thank you. Good morning, Chair Flores, members of the committee. My name is Alicia. I'm here today to respectfully oppose Senate Bill 1610. But first, I want to thank Senator Perry for that committee substitute. I hadn't heard about it until this layout, so I'm really glad to hear about the changes that have been made to the substitute, particularly the penalties that have been amended. And I also want to thank Ms. McLean and her staff for being willing to work with me and my attorneys as we prepare for the upcoming sunset review of the agency. Well, so I'll name that, as we prepare for sunset, we know TICO is coming up for sunset next legislative session. So the main point of our testimony is just that before we make any sort of drastic changes that are going to significantly impact the lives of the people who are imprisoned at the Texas Civil Commitment Center right now, I think it would behoove us to maybe press pause and wait for that review from Sunset, because we know Sunset Commission is, working on TDCJ right now, but they're going to be doing a very thorough look at all of the different areas of TICO. So we would just urge a pause on this bill for that reason. And one of the reasons that we feel that way is because we already have some existing concerns about due process and transparency in this department, particularly just in relation to data collection. So like I said, I'm very grateful for Ms. McLean's willingness to work with us, but as it stands, it's very difficult to understand what all is happening in regards to due process for TICO. And I just want to name that these are individuals who have already served their entire prison sentence out at TDCJ. So they were sentenced by a judge to a sentence for the crime they committed. They've done their time. And then in this sort of extrajudicial process, they go to TICO. And this is not a program that every state has. And so there are just a lot of questions that we have, and we want to make sure that we're protecting due process before we move forward with something like this. Thank you.
Senator Hinojosa, you're recognized.
When a while back, I used to chair the Committee on Criminal Jurisprudence on the House side. And whenever passed this bill out initially, we had some of the same concerns with due process. But the civil commitment process itself, these are people who will never, I guess, do better. They will never change. What is the status? How do you determine that?
So at Texas Civil Rights Project, we don't think any human being is beyond redemption. And so because there was initially a sentence for these folks that a judge and a jury found reasonable for them, we respect that process and feel that there needs to be a little bit added scrutiny about the process of imprisoning people basically indefinitely at TICO right now. There is not a really great transparent system for folks to acquire an attorney prior to their hearing for commitment. And that whole process is really not transparent for at least the folks that we have talked to about it.
I guess the key question, can they be some of these people, can they be rehabilitated?
Absolutely, and I would welcome you to, try to reach out to some of the folks who have been released. Most of the folks who have been released as a result of their lawsuits because of, the claims that they brought about due process, so they were able to appeal to a court and gain their release that way. And so I've met with some of them, and they're wonderful individuals that I think would love to meet with you.
Thank you. Thank you, Mr. Chairman.
Thank you for your testimony. So the chair sees no more witnesses listed. Is there anyone here to testify on, for, or against Committee Substitute for Senate Bill 1610? Hearing none, public testimony is closed, and we will leave this bill pending. What? Chair lays out Senate Bill 836 and recognizes Senator Paxton to explain the bill.
Thank you, Mr. Chairman and members, and thank you for the work that you have done to protect sexual assault survivors. I do have a committee substitute.
So Senator Paxton offers a committee substitute for Senate Bill 836. Any objection? Hearing none, committee substitute is adopted. Please proceed and explain the committee substitute.
Thank you, Mr. Chairman. Senate Bill 836 respects and protects the dignity and agency of sexual assault survivors by providing additional privacy protections based on feedback from survivors when they are going through the criminal justice process. Senate Bill 836 addresses these concerns to ensure that sensitive personal details of sexual crimes are kept private and survivors are not re-traumatized or shamed in the process of seeking justice. The committee substitute reflects additional feedback and conversations with the legal community. The goal of this bill is to protect survivor privacy without placing unfair burdens on the district attorney or the defense. I believe this committee substitute strikes the balance to ensure against unintended consequences in the implementation of the bill. As substituted, Senate Bill 836 prohibits live streaming of trials, which became very popular during COVID, but is a very difficult thing for sexual assault victims. So it prohibits live streaming of trials relating to sexual crimes and for certain protective orders unless consent is given by both parties. It provides the right to request usage of a pseudonym in the prosecution phase rather than only when law enforcement is conducting the investigation. It safeguards evidence of forensic medical examinations by placing them under a protective order, and it expands safeguarding of evidence of invasive visual recordings to adults, not just children, by placing them under protective order, as currently these recordings are only protected for children. Sexual assault and similar crimes are considered to be significantly underreported. We certainly don't want practices in our courts that further discourage survivors from seeking justice. Thank you, Mr. Chairman.
Any questions, members? The hearing none, we'll now open for invited testimony on committee substitute for Senate Bill 836. The chair calls Bronwyn Blake, Sophia Struthers, and Brenda Garrison. So we'll begin on my right, and if you state your name and your...
Sophia Strother Lewis.
Apologize for not saying the Lewis.
That's okay. Thank you, Chairman and fellow senators. Thank you for the opportunity to speak today. As I stated, my name is Sophia Strother Lewis. I am not only a survivor of sexual assault, but a survivor of a system that failed to protect me when I needed it most. Please understand, when someone is raped, abused, or trafficked, they must have to navigate up to 7 systems: family and friends, society, faith, law enforcement, healthcare, the prosecution, and the judicial system, all of which carry their own weights, stereotypes, and prejudices. When I first reported my assault, I believed justice would bring closure. I believed the courtroom would be a place of protection. I was wrong. Because I was not offered an advocate, I wasn't aware of all the protections afforded to me to protect my property from being Googled or my personal, sensitive information sought out. During the prosecution phase, my identity was fully exposed, unbeknownst to me. My name, address, date of birth, social security number became accessible to the very man who violated me. That information was used to track me, harass me, and ultimately destroy my sense of safety. I experienced fraud, identity theft, and the complete collapse of my multi-million-dollar business that I had built. Everything I worked for was gone. A stalker has appeared at the lot since my trial, where I used to house my vans. No one to protect me, including Amazon, who I had a contract with. Before trial, 4 of my vans were blown up. Pictures can be seen via Austin Statesman. Still now, I'm experiencing bank fraud and identity identity theft. My identification is showing up in the dark web, and I'm forced to decide between my safety, sanity, and success. I was forced to give up 4 years of blood, sweat, and sacrifice building my company, L2E. I am now starting the process of personal bankruptcy because one decision to seek justice cost me millions, literally millions. No one prepares you for the life-altering depths you encounter when you decide to live, fight, and seek justice. What did I think would actually happen when I tried to hold an illegal immigrant convicted by the United States government of money laundering, conspiracy, and fraud for being one of the leaders of a 7-person Nigerian money laundering scheme in Houston? What did I think would happen once he was convicted of sexual assault? Once he was able to cut off his ICE monitor and be on the run? The odds were always in his favor the entire time. He's innocent until proven guilty, whether he's illegal or not. He's granted favor by the feds because he was able to get out of a 97-month sentence 2 years later, and protection because he's probably a snitch or an asset. Again, my identity means nothing. All of my information laid barren in front of the court, and again, for him to be able to take. With just retribution on his mind over the last 477 days he's been on the run, I am simply a docket number. And my case, even though it has been won, I'm not a person. I just was able to get a check mark for the prosecution. But worse than that is silence after trial. No advocate, no follow-up, no care. I fell into deep mental and emotional spiral, my self-worth shattered. I couldn't sleep, I couldn't trust, I couldn't function. And trust me, there are still days that I wish I was no longer here. I'm only here today because, again, the trauma of being paraded in public and my dignity left on the courtroom floor. I want to feel like I matter again. This is why I support Senate Bill 836. This bill would have changed my life. It would have changed the lives of even those that came before me, and hopefully it will change those that come after. It will stop the live streaming of sexual assault during trafficking trials as well. It will allow survivors like myself who requested a pseudonym to have the privacy and protection we deserve before, during, and after. It also will provide safeguards of our medical evidence and invasive recordings because our bodies and stories are not exhibits for public consumption. Senate Bill 836 is not just about hiding justice, it's about preserving humanity. Please vote yes. Vote to restore dignity. Vote to give survivors a chance at healing without the additional trauma of being exposed, forgotten, and left to suffer alone. From January 1st of 2021 to today, the last 1,544 days, and I'm still being tortured and raped. When will the bleeding stop? Thank you for your time, and I look forward to you stopping the bleeding with the surgical precision of your vote on yes for Bill 836. Thank you.
Members, any questions? Thank you very much for taking the time to come before this committee and to tell your story and to tell us the compelling reasons why this bill needs to be supported. Thank you. Your name and who you represent, and please proceed with your position.
Thank you, Chairman and members of the committee. My name is Bronwyn Blake, and I serve as the Chief Legal Officer at Texas Advocacy Project. We're a nonprofit that provides free legal services to victims of sexual violence and other crimes, and I've done this work there for almost 2 decades. I want to thank Senator Paxton for filing this important piece of legislation, and I appreciate the opportunity to testify today. Every day, the attorneys that I work with and the advocates that we hear from know that survivors are deciding whether to report sexual violence and engage with the criminal justice system or not. And far too often, that decision hinges on one painful fear: will my story be made public? Per the Texas Constitution, a crime victim has the right to be treated with fairness and with respect for the victim's dignity and privacy throughout the criminal justice process. Unfortunately, this does not align with what many survivors of sex crimes experience during the prosecution of their case. Survivors of sexual assault have already endured a profound violation of their autonomy. When they make the brave decision to come forward and participate in the criminal justice process, they deserve a system that protects them, not one that re-exposes them to trauma. SB 836 will create important and necessary safeguards for victims in order to encourage their continued participation in the criminal justice process, something that benefits every single one of us. This bill includes 3 critical safeguards: the limits on live streaming requiring consent of all parties, flexibility in pseudonym request, and common sense safeguards for protective orders protecting sensitive information. Survivors should never have to choose between their privacy and the pursuit of justice. By supporting SB 836, we're not only protecting sensitive information, we are sending a message that survivors matter, that their experiences deserve respect, and that the criminal justice can and must do better. On behalf of the thousands of survivors that the Texas Advocacy Project serves every year, I urge you to support this bill. Thank you for your time, your leadership, and your commitment to survivors. I'm available for any questions.
Any questions, members? And thank you for taking time to be here as well. Please.
Good morning, Chair Flores, members of this committee. I appreciate taking the time or the opportunity to speak with you. I'm here to support Senate Bill 836. I started my career as a sexual assault nurse examiner in 1993. In 1996, I opened the first private facility in the state of Texas to care for and do the forensic medical examinations on sexual assault patients. My goal then and remains today to provide them with the privacy, dignity, and confidentiality that they deserve. Live streaming via the internet undermines everything we stand for. It benefits no one except the people watching for entertainment. Don't think we haven't tried to stop this at a local level, because we have. What we're told is there's nothing they can do. It's the judge's discretion. Victims of sexual assault are forced to relive their trauma in court. Live streaming exposes them to an unlimited public audience, compounding their suffering unnecessarily. I ask you, should victims be forced to relive their trauma for the world? Transparency doesn't require re-victimization. In one national study, 33% of rape survivors said they had contemplated suicide, and that was prior to live streaming. Those who had been raped were 13 times more likely than non-crime victims to have attempted suicide. I ask you, do we really want to expose these victims to further trauma? Sexual assault trials involve deeply personal, graphic testimony. Live streaming turns justice into entertainment for casual viewers. It makes a mockery out of our courts. I ask you, should the dignity of victims, witnesses, be sacrificed for public curiosity? How would you feel if your wife, mother, daughter, or son intimate testimony was broadcast over the internet? What if the accused is found not guilty? The viewers will never unhear what they have heard. In court, participants know who is present. Live streaming removes that awareness. Victims don't know who now knows intimate details, neighbors, coworkers, strangers. Once put on the internet, it can resurface years later. And I ask you, how does this serve justice, the victims or the accused, when their privacy is stripped without consent? As a sexual assault nurse examiner, I've received many letters from incarcerated individuals over the years. Although these are not direct threats, they are still letting me know they know who I am, where I am, and how to reach me, which is a serious concern. Live streaming increases the exposure of the expert witness. And I ask you, why wait until something happens and then it's too late? Live streams can be recorded, edited, and spread without context or consent, leading to harassment, bullying, and public shaming. Are we prepared for the fallout when sensitive evidence circulates online? Posting a do not record order on your website only makes predators laugh at this idea. Courtrooms are open. Anyone can attend in person. Live streaming isn't necessary for transparency. It's a step towards spectacle. Is live streaming truly about access, or is it inviting exploitation? My concern for safety is not theoretical. In 2012, a tragic shooting related to a sexual assault case took the life of a woman in the parking lot just steps away from the Jefferson County Courthouse. Don't put another roadblock for victims for them to be able to come forward knowing that their case may be live streamed. We have had others when families were led to believe that their case would not be live streamed, just to find out later that it had been. Please consider passing Senate Bill 836. The justice process deserves protection. Let's be transparent, but not at the cost of dignity and due process.
Thank you for your testimony. Please state your name and begin for the record.
I'm sorry, Brenda Garrison. And I also have a letter from a survivor that I would like to present or leave with you.
You may leave it in writing, or unless members want to hear the letter, or submit it, if you please. Any questions, members? Show Senator King is present and the quorum is established. Thank you all very much.
Thank you.
Also, Senator Hinojosa moves adoption of committee substitute Senate Bill 836. Any objection? Hearing none, so ordered. Is this individual public or invited? Okay. So the chair, so hearing no more invited testimony is now closed. The chair now opens the floor for public testimony. The chair calls Alan Place. Alan Place.
Good morning, Senator. My name is Alan Place on behalf of Texas Criminal Defense Lawyers Association. I signed up on the bill. I was going to speak. Based on the committee substitutes, we read it. We have no opposition to it going forward. We want to thank Senator Paxton and her staff and others for working with us to get us a bill that everybody can live with.
Well, thank you very much for taking time to come and testify. And Senators, any questions? Thank you very much. Seeing no one else signed up to testify for public testimony, is there anyone here on, for, or against committee substitute for Senate Bill 836? Hearing none, public testimony is closed, and we will leave the bill pending. When we have a quorum, then we just work them all out. 1563. Chair lays out Senate Bill 1563 and recognizes Senator Menendez to explain the bill.
Thank you very much, Mr. Chairman. Good morning, members. And Chairman Flores, it's great to be with you all here, and thank you for allowing me to bring this bill forward. This is a bill that would require that all county jailers receive training on interacting with veterans in their jails. Look, we know that there are hundreds of veterans in our county jails right now. Matter of fact, 2012 report on veterans who had deployed to Iraq and Afghanistan, it was estimated that approximately 9% of those veterans had been arrested after they came home. We know that many of our veterans have endured trauma related to their service, especially if they engaged in combat. And while it's important to protect our community and keep folks detained if they are in a danger to others, jails can be very stressful and can make inmates who are veterans a danger to themselves and others. And we don't need any more veterans taking their lives. In fact, a jail can exacerbate behavioral problems, and veterans may leave our jails worse than when they came in. What we're hoping is that this training will be developed in collaboration with the Texas Veterans Commission to ensure that we are meeting veterans where they are, and that this program is made with veterans in mind, by veterans, for veterans. As of now, county jailers must complete a preparatory training program with a minimum of 8 hours of mental health training. And while modules within the mental health and crisis intervention training may include scenarios or briefly mention veterans, there's no actual dedicated required training towards this specific population. Knowing that our veterans have a unique and often complex mental and behavioral health needs, it is my belief that our jailers must ensure they are safe and supported while in our jails. Mr. Chairman, members, today we have Mr. Stephen Price, a constituent of Senate District 26, who is a veteran who has worked for years on helping veterans. He's going to share how he believes his training is going to help the veterans in our jails. And I know I don't need to remind this committee because of his experience, but just for the people watching, only 1% of all Americans ever sign up to defend this country and represent this country in our armed forces. And so I think we owe it to them to do this. And so thank you, Mr. Chairman. I'm willing to take any questions, comments, or rude remarks from anybody on the dais.
Members, any questions of Senator Menendez? Hearing none, invited testimony for Senate Bill 1563 is now open. Chair calls Dr. Blake Harris and Stephen Price. You'll come forward. We'll begin on my right. If you'll state your name and your position on the bill, and please continue with your testimony.
Good afternoon, Mr. Chairman. My name is Stephen Price. I represent the voices of our veterans from San Antonio and Military City, USA, and obviously my Senator, Jose Menendez. Good evening, honored guest. Where do I start? As we know in the recent news, the air conditionings in the prison were noted as being turned off and as a form of punishment for our general population. Our veterans are a different population. We trained them to fight. We trained them to go into combat. We even call some of them devil dogs. Marines, Semper Fi for the Marines. A dog that's trained to fight, to go into combat, defend himself, comes back home, finds himself in trouble, finds himself in prison. We have dogs, pit bull dogs, that we can reference and cross-reference in this theory. You bring the dog home, you get to trouble, you put it in a cage, you expect it to treat the other dogs in that cage and the people in the world in a manner that none of you, maybe only a combat veteran, can understand. When you come back and to be put into a position in a place where you're locked in, the temperature's changed, you're treated like an animal. I can't get in an elevator for some reason. Even getting in the elevator just now with our dear Pearl, I get word that I'm going to be locked in. Can you imagine being locked in a solitary confinement cell because you have PTSD? They turn down the lights, they change the temperature. What's going to happen? You're either going to attack somebody or you're going to attack yourself. You're going to end up killing yourself. So some of the numbers, if you would please yield while I read some of the statistical data that I brought. Veterans are one of the highest risk populations for suicide in the United States, according to the Department of Veterans Affairs. The suicide rate amongst veterans is almost 60% greater than it is for non-veterans. Veterans also have an elevated rate of contact with the criminal justice systems, which may range from arrest to sentencing to incarceration. And recent research suggests that the involvement can further exacerbate the suicide risk. Numerous factors contribute to the high suicide rate among veterans. Many veterans face a range of difficulties when returning home and reintegrating back into civilian life. Military service can result in serious health conditions, including post-traumatic stress disorder, depression, substance use disorder. What happens when you go to jail? Can't go to the VA hospital. You're left alone. The minute you ask for help, you might even be ostracized. We've asked, and I've asked before, that the state might separate some of these veterans and put them into air conditioning facilities, and we haven't gotten there yet. Dr. Amit Dominique, I speak on her behalf, we would love to see that we could put some air conditioning and actually regulate what's happening to these prisoners. Our senator, there's a training mechanism for TCLO where we can send actually trainers into the prison and train our officers how to relate with these veterans. Not that we want to separate them and make them any different than the rest, but there is a factor of confrontation between the prisoner already and the guards. Can you imagine if I go in there as a devil dog and I'm all hoorah, semper fi? They're going to beat me down and lock me up, and probably within a matter of 5 days, I'll find some way to kill myself. Right, Doc?
It can happen.
I'll find a way. I'll find a way if I have to start banging my head against the wall, and that's what happens. So please, Senator, you know I love you, brother. Okay, the rest of you, Cesar, I see you popped in the back. My veteran brothers in the room, they understand. They understand this dog. And I impress upon the rest of you as you go through this session to remember that we're not all sick. We were trained to be this way. You have to train us and help us to get back to where we used to be. That friendly pit bull, that friendly dog that'll behave in society. This is my 101st testimony trying to save veterans' lives. Please pass this bill.
Members, any questions? Senator Hinojosa, you're recognized.
Thank you, Mr. Chairman. You know, one of the things that has happened, we have really worked very hard to provide proper support for our veterans coming in from Afghanistan and up in Desert Storm. Much better services. Still, when you have over 18 veterans commit suicide a day, there's way too many. While yes, they probably need some special attention in jails, it also is the responsibility of the community as a whole to provide support for veterans. You know, when I came back from Vietnam, the United States Marine Corps, there were no support for veterans, and many committed suicide. Many of them became drug addicts, and many of them went into crime. So yeah, I'm pretty familiar with that issue, but the type of services that we have worked to provide and provide support to veterans has extended and expanded, quite frankly, to try to help them. But the key is community support, community involvement. And I understand having to have our jail systems have some, at least, orientation as to how to deal with veterans that came in from war zone and have PTSD. So,
yes, sir.
So we'll move in that direction.
Thank you, sir.
Thank you for your service.
Thank you, sir.
The clerk shows Senator Miles and Senator Huffman present. Any other question for Senator Menendez?
Mr. Chairman, I was just curious. We're going to hear from Mr. Blake, Dr. Blake, right? Okay,
yes.
Great. That's what I wanted.
You may proceed. State your name and please proceed.
Hi, thank you. Chair, committee members, I'm Dr. Blake Harris. I'm a licensed clinical forensic psychologist, and I'm the director of the Veterans Mental Health Department for the Texas Veterans Commission. That department is made up of our Veteran Suicide Prevention Program, which is our #1 priority, our Homeless Veteran Program, our community and faith-based partnerships, and our provider training program, and our Military Veteran Peer Network. Those are TVC certified peer service coordinators that often do a lot of work within the TDCJ prison system, as well as in community jails. And then certainly our Justice Involved Veteran Program, which is focused on working at each step of the sequential intercept model. We do a lot of training with law enforcement. We work very closely with Texas Commission on Law Enforcement currently on a training that is called 4067. That is where law enforcement can get continued education hours on how to work with trauma-affected veterans. We have a great partnership with TCOL in that training. We work also closely with the Texas Commission on Jail Standards to identify veterans when they're coming into the jails so we can leverage all the community resources and the state resources for veterans and try and divert them. We also support all of the veteran treatment courts in Texas. And we also work closely, as I said, with TDCJ on the reentry work for veteran-specific issues, and also with community supervision for that step down when folks come back into probation and parole. So we really do try to be intentional across that system. One of the things that we have already begun, and I was just connecting with Mr. Grissom from TCOL this morning. Our Justice Involved program managers are already actively working with their lead trainer, Rachel Reinhardt, great partner and collaborator, to develop a training for jailers on veterans issues to address some of the things that our friend Mr. Price noted, and also the Senator Hinojosa, about making sure that we have staff that are available and ready to identify veterans' needs and how to meet those needs. I will say there are a lot of successes, certainly within the TDCJ system and the prison system. There's a lot of veteran pods where veterans are put together. They go through morning reverie, and then they work together and do a lot of peer groups. Our MVPN participates in that as well. And then certainly in some of those larger jails, we've had success with getting veterans together and running veteran groups. I think educating jailers on veteran needs is certainly important. And we're committed to working with our partners at the Texas Commission on Law Enforcement to make sure that those jailers can get those CEU hours. We do understand there is staff shortages across the state for jailers, and we understand that it's shift work, and you have a lot of folks working midnight to 8 trying to do all that training. So we're working actively with T. Cole's training team to make sure that we can make something that's accessible, something that's quick, and something that's on-demand learning, so they can still get that the exposure to all the things that they need to identify what are some of the common factors for veterans, what are some of the resources that are available for them, because someone may be in jail for a minute, someone may be in jail for 364 days. So for however long they're there, we want to make sure that they're aware of their claims benefits, all the things that help support their family while they are maybe incarcerated, and all the things to help them get their back on their feet that are offered by the Texas Veterans Commission, Texas Workforce Commission, and a lot of the other state and local entities that have a big interest and footprint in serving veterans. I'm more than happy to answer any questions.
Members, any questions? Senator Menendez.
Thank you, Mr. Chairman. Doctor, it sounds like you guys are way down the road already on creating this training with T. Cole, so you're doing this. Do you find sometimes that veterans just aren't aware of the resources that are out there?
Yeah, and typically when I start any presentation and I say I'm with the Texas Veterans Commission, I try and remind people I'm not with the VA because there are a lot of veterans across Texas, and maybe some in this room, who are really unaware of all the benefits, whether that be education, employment, entrepreneurship, mental health services that are available to them that may be outside or complementary to the services that our partners within the federal VA offer. We also know that when we're training law enforcement, somewhere around roughly 40% of law enforcement in Texas are also prior military. And when we do that trauma-affected veteran training, it never fails that when we're training the law enforcement, excuse me, on how to work with veterans, we have law enforcement officers say, hey, me or my buddy or one of my peers needs those services. We also know that there are a lot of veterans that work in corrections. So having jail staff be aware, it's meaningful and it holds weight.
So the suicide rate, we know nationally is around 22 a day. If my last count, I think, may have gotten it down to 21 or 20.
You know, it's hard to say the exact numbers because the VA, the federal VA, does the most robust analysis on suicide. There's a lot of issues like what is an accident, what is a suicide, things like that. What typically folks can agree on is a range of somewhere between 17 to 22, but we're seeing that it has not gone down. We're seeing now the effects of COVID. Typically, it takes 2 years to get all the research done. There's efforts here locally in Texas to do faster analysis. But yes, it is.
That's where I'm going with my question is, Doctor, and sorry to interrupt, is I would imagine, and you've interacted with them, that sometimes people, when they've made the decision to take their lives, is because they don't believe there's any other way out. There's nothing, no reason to.
Hopelessness is the number one risk factor. And what we find is, from folks who have had suicide attempts and survived, typically, you know, the time frame from saying, a lot of folks may think about suicide, they may have ideation, they may contemplate it, but from making that decision, I'm going to do it, to acting on it, 10 minutes is often the window. And even in secured settings, it can be accomplished within 2 to 3 minutes. Someone can end their own life.
So the training that we would provide jailers who are interacting with someone who may be close to that decision, it'd be vital to identify and to step in and to possibly save some lives.
When you think that someone's in the jail system, they're at that's a low point. Particularly for veterans, there's a lot of folks that get concerned that they're going to lose their benefits, or now they're not going to be able to take care of their family. It can exacerbate that feeling of hopelessness. So we do know that there is an advanced risk for suicide risk for veterans when they are in the justice system. So that is a high risk time, potentially.
Thank you, Doctor. I have no further questions, Mr. Chairman.
Members, any questions? Thank you both very much for being here. Thank you for taking the time to come visit with us. Seeing no other invited witnesses on this bill, the chair closes invited testimony. The chair now opens public testimony. Chair calls the following witnesses. Mitch Fuller. Identify yourself and your position on the bill, and please proceed.
Good morning, Mr. Chairman, Senators. My name is Mitch Fuller. I'm the Legislative Director for the VFW Department of Texas, and I'm here in support of this bill. And Senator Menez, thank you for bringing this bill forward. I think the particular benefit and value of this bill is it is going to help the Veterans Treatment Court system. So the state of Texas has done a wonderful job with the Veterans Treatment Court system. And I'm involved with the one in Williamson County. Judge Barker is tremendous in how she runs that court. And so if a veteran gets a DUI, there's a lot. That's one example of diversion to the Veterans Treatment Court system. So if they're incarcerated in a county jail temporarily, this bill is a huge value for those jailers to assist that veteran, because that's a traumatic experience. And I have seen veterans that I have served with who've gone through the Veterans Treatment Court system, and it's a life changer. It's life-saving. So this is a way to augment that system in a very good way. There's about 8,000 veterans incarcerated across Texas in the prison system and the county jail system. So this is a great bill. Thank you.
Members, any questions? Thank you for being here. So seeing no more, any more people signed up for public testimony, is there anyone here on, for, or against Senate Bill 1563 wish to testify? Hearing none, public testimony is closed, and we will put this bill as pending. Let me call up.
Okay.
Senator Blanco, what's that bill?
906.
Chair calls up Senate Bill 906 and recognizes Senator Blanco to explain the bill. Show Senator Parker is present. Vice Chair Parker. Yes. Please proceed.
Thank you, Mr. Chairman, members, for allowing me to lay out Senate Bill 906. Currently, 2 of 3 federally recognized tribes in the state of Texas, the Alabama Coushatta Indian tribe and the Kickapoo Traditional Tribe of Texas, have the authority to employ and commission peace officers to enforce state laws within tribal land. This bill would give the Isleta del Sur Pueblo in El Paso County that same authority. We do have resource witnesses from TCOLF if we have any questions, but respectfully request passage of Senate Bill 906.
So this is going to be the same as the bills that we passed previously for the Alabama Coushatta and the Kickapoo.
That's correct, Chairman. Those bills were passed in 2011 and 2019, but same authority.
Yes, I did the Kickapoo one, so very familiar with this as well. So members, any questions? So at this time, we'll call up for invited testimony. The floor is open for invited testimony. We call up Governor Michael Silvas of the Isleta del Sur Pueblo Tribal Council and Chief Robert Martinez, also for the Isleta del Sur Pueblo Tribal Police Department. You'll come forward. We'll start on my right, if you can, Chief, if you can proceed.
Good morning. Michael Silvas, Governor for Isleta del Sur Pueblo.
Thank you, Governor.
Yes. So if I may, please open up with a prayer in my language. If I may,
Please.
Auki hawe eu de itu de aite hau turi de an hau pai de an hau pai hlan haus highly soon bien Dios be a biche hau. Thank you. Good morning, Chairman and members of the committee. I am Michael Silvas, and I serve as governor of the Isleta del Sur Pueblo, one of only 3 federally recognized tribes in Texas. We are located in El Paso County, where our pueblo has existed since 1682. Today, we serve a growing population of over 5,000 tribal members. A self-governing tribal nation, we provide a full range of governmental services, including education, healthcare, economic development, and law enforcement. As governor, my first responsibility is public safety. That is why I'm here today, to respectfully ask for the support of granting our tribal police department the authority to be commissioned as peace officers under Texas law. Currently, our officers operate under a special law enforcement commission from the Bureau of Indian Affairs. This allows them to enforce federal laws, but not Texas laws. That means if they respond to a situation that falls under state jurisdiction, even in our land, they must wait for another agency to take over. This creates avoidable delays and, worse, real safety risk for victims, for officers, and for the surrounding community. El Paso is a border community, and our officers are frequently called to respond alongside federal, state, and local agencies, including CBP, DPS, and the El Paso County Sheriff's Office. But unlike other departments, our officers are limited in how they can respond, even when the situation is urgent. We are not asking for special treatment. We are asking for equal footing. The Alabama Coshada Tribe of Texas, the Kickapoo Tribe, traditional tribe of Texas, already have officers who are commissioned by the state of Texas. We are simply asking for the same opportunity. Let me be clear, our officers are not only ready, they are already doing the work. They have completed full law enforcement training, maintained up-to-date firearms and readiness certifications, and passed a thorough background screening. This model works in other states, Arizona, New Mexico, Oklahoma, and it can also work in Texas. We believe this change will improve coordination, eliminate confusion, and most importantly, enhance safety for our people and for the surrounding region. Thank you for your time today, and I respectfully ask for your support.
Good morning, Chair and committee members. I am Robert Martinez, Jr., and I serve as the Chief of Police for Isleta del Sur Pueblo. I strongly support SB 906, granting my officers the authority to enforce Texas state laws on tribal lands. This authority is not only necessary but critical. My officers actively patrol our community and respond to threats in real time. However, when calls involve non-tribal individuals, currently limitations force them to wait for outside law enforcement. These delays put public safety at risk and highlight the urgent need for state law enforcement authority. The Isleta del Sur Pueblo Tribal Police Department consists of sworn force of 20 officers who operate 24 hours a day, 7 days a week. We serve a community over 5,000 tribal members and approximately 1,000 daily visitors. My officers protect a checkerboard reservation covering over 420 acres within 2 main districts located within 8 miles of each other. Additionally, our officers are responsible for the Chilecote Ranch, a vast area of approximately 70,000 acres in Jeff Davis and Presidio counties. While criminal jurisdiction in Indian country is complex, the general authority of law enforcement officers in Indian country is settled issues of federal laws. Tribes generally lack criminal jurisdiction over non-Indian offenders, and tribal officers are limited to the ability to arrest non-Indian offenders. These creates a significant challenges in maintaining public safety and underscores the importance of SB 906. Other tribes in Texas, including the Alabama Coshada and Kickapoo Traditional Tribe, already commission officers under Texas law. Isleta Sioux Pueblo seeks the same recognition and to ensure the safety of our people and the surrounding El Paso community. We are fully committed to meeting TCO's training, certification, and accountability standards. Our officers maintain the highest level of professionalism, and this authority will allow them to serve more effectively. By granting this measure, we improve public safety and strengthen cooperation between local, state, and federal agencies. Thank you.
Thank you. Members, any questions? Any questions? And thank you. Yes, I was going to ask the question of the certification with TCOL as state peace officers that the others were required to do that. So I was glad to hear that it was going to be the same requirement.
Yes, sir.
For professionalism. Thank you. Thank you very much. Thank you for being here.
Thank you.
Thank you.
Seeing no more invited witnesses, invited testimony on this bill is now closed. The chair now opens public testimony, and the chair calls the following witness, Raul Candelaria. Welcome. Your name and your position on the bill.
Good morning, Chair and members of the committee. My name is Raul Candelaria, Jr. For the past 36 years, I have proudly served my tribe, the Isleta Sur Pueblo, and I currently hold the role of Director of Public Safety. I appear before you today in strong support of SB 906, requesting to grant our tribal police department the authority to be commissioned as peace officers under Texas law. When I first joined the Pueblo's public safety team, we were not a police department. We were a security unit doing our best to meet the basic safety needs of the community. Over the decades, I've worked shoulder to shoulder with our tribal council, tribal leadership, Chief of Police Martinez, and countless dedicated officers to grow the humble operations into a fully operational police department. This journey has been one of transformations of structure, of capability, and responsibility. In 2012, I led the department efforts to secure a special law enforcement commission from the Bureau of Indian Affairs, giving our officers authority to enforce federal law in Indian country. That was a breakthrough, but it didn't resolve the most significant challenges we still face in inability to enforce Texas state law. Even with the threats of public safety demands, immediate actions, that barrier exists between our jurisdictional limits imposed our tribe by the Restoration Act. The limitations affect the safety of our community. As a border tribe in El Paso, we work side by side with federal partners, DPS, FBI, local law enforcement. This is not just personal for me. It's deeply personal, been a part of the department from the start. I've seen officers grow into leaders. I know their families, help them trained, guide them, support them. I take pride in what we have built. Again, I'm here to respectfully ask you to support the Senate Bill 906.
Thank you very much for coming, and thank you for your testimony. It's been a long way for you to travel. Any questions, members? Thank you very much.
Thank you, sir. Thank you.
Thank you for being here.
So seeing no one else registered for public testimony, is there anyone here to testify on, for, or against the Senate Bill 906? If not, public testimony is closed, and we will hold that pending when we vote the bunch of bills out. I want to hear as much, while we're on a roll, let's hear as much as we can, and then vote them out. Is that okay with the members? Okay, give me Senator King's bills. Not seeing it. I'm not seeing what. There it is. Chair calls up Senate Bill 781 and recognizes Senator King. And Senator Hagenbooth offers a committee substitute for Senate Bill 781. Any objection, considering the committee substitute for Senate Bill 781? Hearing none, so ordered. Recognize Senator King to explain the bill and the committee substitute for committee substitute for Senate Bill 781.
Thank you, Mr. Chairman. Members, currently there is no standardized practice that Texas law enforcement agencies follow in determining the confidentiality and release of a peace officer's personal information. Instead, the confidentiality of a officers' personal information, such as names and addresses of themselves and family members, is dependent upon the policies of their employing political subdivision. As a result, peace officers' personal information has been subject to requests and scrutiny by political organizations and media outlets. To protect peace officers' personal information, some cities have adopted policies in their charter clarifying that a peace officer's personal information must stay confidential. Senate Bill 781 seeks to standardize these practices and make them applicable to all peace officers in Texas. Furthermore, all state-level peace officers, such as DPS, have a similar process already in place for containing a license holder's personal information. Senate Bill 781 codifies the Texas Commission on Law Enforcement's model policies into state statute. So this is a TCO model policy, and we'd just be codifying it into state statute. Senate Bill 781 clarifies a department file contains a peace officer's personal documents and requires this information to remain confidential. Under Senate Bill 781, a peace officer's department file will still be available for department requests relating to misconduct investigations and standard hiring practices, and as part of ongoing investigations by TCO. The committee substitute is simply a ledge council version of the bill, and we have a number of witnesses here today from CLEAT and TCO as a resource, and then a couple of law enforcement agencies. Be happy to answer any questions.
What's that? Any questions? I have a question. Senator Huffman.
Senator King, I just have a question about, can't remember which session it was, it's been several sessions ago that we passed the legislation to stop the rehiring of police officers who had engaged in misconduct and so forth. And there's a lot of requirements and, that you have to pass on information to the new hiring agency. This wouldn't affect that in any way, would it?
No, not at all. That information will still pass on to an inquiring agency.
All right. Just wanted to verify.
It also won't affect Michael Morton's law or anything like that we've put in place separately and distinctly. Thank you for the question.
Yes.
Senator Hinojosa.
Thank you, Mr. Chairman. I guess what I'm following up on Senator Huffman's question, for many years we worked very hard to get the personal files of law enforcement officers just right. And now we're moving to the direction of what's the purpose of your bill? And I apologize, I wasn't here when you started laying out.
Okay, sure.
Is it protect Social Security, personal information?
Personal information, family members' names. So basically, like DPS has two files. One's what they call the department file, and the other's the personnel file. Personnel file will have all their training and performance records, disciplinary records, things of that nature available in it. The department file has your background investigation from when you were, first applied for your family members' names, contact information on you and your family, your home address, and things like that. Well, those in many, if not most agencies, are all in one file. And so when there's an open records request or something else like that, that stuff gets released too. And so this just separates them and says that this personal information is not subject to release except under certain circumstances, which would be a disciplinary investigation or another agency you've applied to go to work for looking for it or something like that. It's just trying to keep it out of media hands or out of some political organization's hands.
It's somewhat confusing because under present law, personal information like Social Security, family address, home addresses are already required not to be disclosed.
Yeah, there's some witnesses today that will testify that it is getting out, and but I will say this, that what we're putting into place is the model policy for management of files that has been developed by the Texas Commission on Law Enforcement. And we're just taking that model policy that they've developed in peer review and in their work groups and incorporating that into state statute so that it's uniformly used across the state.
And it's kind of confusing because if we look at the section 1701.4535, personnel file information right now under present law, it says a letter, memorandum, or document relating to alleged misconduct by the license holder may not be placed in the license holder's personnel file if the employing agency determines that there is insufficient evidence to sustain the charge of misconduct. And your bill doesn't really reference to any privacy issues. It really just focuses on exactly what is already prevented in law.
That is partially, what you said is absolutely correct with regard to the occupations codes that you cited. What we're trying to do here is make sure that the private personal information of law enforcement officers doesn't get released to politically motivated individuals or groups and media outlets as is currently happening. And so, yes, you're correct. We are protecting already in the occupations code, protecting if they were accused of of misconduct and that was not sustained, then that is not released. Now, in their personnel file, it would be released if they had gotten 10 days off for slapping somebody or some other misconduct.
Well, but as I read Senate Bill 781, I don't see any of the specific data elements on privacy in it. I see mostly focuses on entire conduct-related department files, keeping them confidential. So your bill, I think, is very confusing to the system we have in place. I think we're going to make any changes. We ought to just make them to the system we have in place and some adjustments. But I don't think we should file a new bill. It's like creating a shadow file, and it's going to be very confusing. I think our law enforcement can be protected already under present law. If we need to tighten that up, we can. But I don't see that in your bill as filed.
So an example might be in BNC this morning, they passed out a bill that for college presidents, because when all the disturbances that took place in 2021 and circa 2021, that college presidents' home addresses and family members' names and personal phone numbers and things like that were getting out through open records and other requests. And so they passed a bill out of BNC this morning that said, no, just like your and my information, if someone makes an open records request or something to the state, your personal information, where you live, your family members' names, things like that are not released. And in fact, you're able to remove that from any public record, like the property tax records, things like that. A few sessions back, circa 2021, I remember I got a call one night from the Dallas mayor, former House member, we all know, and good friend. And he called up and he said, I'm rushing home right now. He said, they're protesting at my house. Nikki and the kids are terrified. And so he said, and so we passed a bill that session that said that their private home information cannot be released. And that's really what at least I see as the heart of this, is trying to make sure that no public request can be made that's going to get an officer's home address, their mobile phone number, their wife's name, their children's names released.
Well, and I agree with you, but that's already in the law. So why are we changing and creating another second file when the law already prohibits? And when you talk about a dean or president of a university, that's very different in law enforcement. We provided law enforcement the protection already. I'm just concerned that your bill itself doesn't spell that out. Your bill focuses more on any alleged misconduct where there was nothing to substantiate.
Right.
And that's already also in statute.
And I agree that that's already in statute. It just seemed good to put that in that same department file. Maybe what we could do, if you have no objection, would be to get some of the witnesses up here, resource witnesses, and I think they can tell you where they're seeing some problems occur and where there's some gaps, and also why it was necessary for TCOL to develop a model policy and that model policy is really not being practiced.
Well, and I don't have any issues with trying to plug those holes as you describe them, because I do want our police protected.
Right.
I just don't
I think
see.
we're on the same page. Maybe we can get some clarification from some of the witnesses.
Well, and I'd like to work some more with you on this bill. but
Absolutely.
I just have some issues the way it's written.
Absolutely.
Senator Miles.
Thank you, Mr. Chairman. Senator King, from one law enforcement officer to a former law enforcement officer, I want to commend you for the first part of this bill, which is already on statute, that we keep law enforcement officers' private and personal information concealed. Yeoman's job on that part. But it is already on the books. I got some strong concern because I've been filing a bill for the last 19 years on your second part of the bill to make sure that information transfers with the police officer. And as Senator Hinojosa was saying, you've got down here misconduct resulting in disciplinary action for the license holder of the supervisor or supervisor. So, clarification, you're wanting to seal a police officer's records if they've been accused of misconduct, or something abusive. You want to seal that in this bill, the second part of this bill. Is that correct?
No.
Talk to me.
And I'm sorry if I'm
wasn't
clear. So if it's already protected, if they have been, somebody filed a complaint against them and it was not sustained, it was dismissed, found to be frivolous, then those are already not released to the public. What I'm trying to say how to say this. The information that you're speaking about would still be available anytime there is a disciplinary investigation, including a criminal investigation. It would still be available to any other law enforcement agency that someone had applied for work at, maybe trying to go to a different department.
Are you sure about that?
That's the way I understand the bill. If I'm wrong, we can fix that part.
But we need to talk about that because I understand that if they have not found guilty on those allegations,
that is
as Texas state law stands now, those allegations don't move forward with them.
Right. If you've been accused of
so if I could, if an officer has been accused of excessive brutality 6 times but never found guilty of it, it does not move forward in his file. And a DA could use that to show mindset and can show purpose, mentality state. And I think what you're doing in this bill is trying to cover it up even more. Is that correct?
That's not the intent.
Okay. But it may not be the intent, but as I read it, that's what I interpret.
I think what
and I'm a former law enforcement,
got that.
and I try to protect our blue, but as I read this bill, it further tries to bury it under.
So it does separate it, I think, so that it is not inadvertently released, separates it into the department file. But I think what I'm trying to do is take what I understand the model legislation of TCO and trying to put that into statute.
And then I have another...
Apparently getting released when it should not be released.
And then I have another concern for your bill that you might want to be aware of. This bill may have 2 different subjects. Because now you're talking about personal information. You're talking about personal information, Mr. Chairman. And then it moves into workplace information.
Well, that's
to me,
hadn't thought
as a former House member, that's a 2 subject. Tanya?
Okay. I'll consider that.
Okay. I've been filing a bill for 19 years to make sure that the disciplinary information moves on. And it's been backed by DAs. Look, 90% of our officers, 99% of our officers are good officers. but we cannot deny the fact that there's always one or two. And those one or two give the 99 bad names and bad reputations and bad images. If you've got an officer that's been accused of abusive tactics 6 times, something's wrong there.
And of course,
but if it's not been found to be guilty on those, from a DA would love to say, I'm sure, that that's in his file.
Now, flip side on that is, I can't think, there probably are some, but it would be an extreme rarity for someone to have 6 different complaints filed against them in completely different instances, and for there not to have been some disciplinary action on that. However,
I've seen some files where they move from department to department to department to department with the same complaints.
That is where you would run into something like that, possibly. And we've tried to do some things to shore that up. I think you also have the flip side of that, where you have good officers. You know, I remember when I first got hired, an old officer said, he said, Phil, you never get fired for doing too little, you get fired for doing too much. And so the flip side of that is that you have good officers who are out there working hard, and they generate complaints because people are trying to, you just arrested me, so I'm going to go in and allege a violation against you to try to help me beat this charge. And so there's a great deal of that occurs too. So it's a real quagmire, I understand.
Well, perhaps we can call the witnesses up, that invite a testimony, and then we can hear what they have to say, and then we can ask some questions, senators.
There's one caveat, Mr. Chairman. One caveat.
Yes, sir.
The way this bill is written in this section, this bill is intended to, may have been his intent or not, it's going to put complaints further and further underground and buried. And that's not, I don't think that's what Senator King intended. So, as Senator Hinojosa said, we need to work on that part, that one section.
If it's got issues, we can fix it.
Thank you, sir.
Any more questions, senators? So invited testimony on Senate Bill, Committee Substitute for Senate Bill 781 is now open. The chair calls Jonathan Blanchard, Jennifer Zemansky, John Beauchamp, and Danny Keel.
You read that right. You read it right.
Thank you all for being here. We're going to begin on my right and state your name and then begin your testimony, please.
Good morning, Chair and committee members. My name is Jonathan Blanchard. I'm a lieutenant with the Dallas Police Department. I'm here representing the Dallas Police Department to talk about this bill. We're in favor of it. About 4 years ago, we attempted to implement an early warning system.
Could you move the mic closer to? Thank you.
I'm sorry. About 4 years ago, we attempted to implement an early warning system for our officers, kind of an algorithmic-based identification to identify possible officers that need intervention. Fellow agencies in Houston and Austin have a similar program, but once we were made aware that even though like a report from this automated system may identify an officer, they may be identified because they either have a number of complaints or they're an overperformer. And phase 1 of that system would make this report, and the report would be publicly available. We declined to proceed with that because of the publicly available of this report. So right now we're waiting to see if we can pass this bill so we can be afforded Chapter 143 protections like other agencies to keep this in a department file. It's still going to be there. It's still going to be available to the DA if they want it. It's still going to be available to TCOL or other agencies that come, but it wouldn't be publicly available because it would not necessarily be an accurate representation of the officer's performance. And thank you for the opportunity to speak about this bill.
Members, any questions?
Thank you for being here.
I'm Jennifer Szymanski, Deputy Executive Director of the Combined Law Enforcement Associations of Texas, or CLEAT, speaking in favor of Senate Bill 781. This came from the T-Cole Sunset Bill last session. That bill mandated that the Texas Commission on Law Enforcement put together committees of stakeholders to develop model policies. Of course, when we do model policies, the purpose and intent behind that from the legislature is to standardize the way we do things across Texas law enforcement to the best of our ability. One of those policies, there were many policies developed. CLEAT and many other stakeholders had a seat at the table on these committees. One of the policies was personnel files and how those are handled and managed in these departments. I sat on this committee, and I can tell you, and from the other committees where my cohort sat on them, I can tell you that the gold standard for law enforcement is Chapter 143 of the Local Government Code. And Fort Worth, Houston, many of the agencies in Senator Hinojosa's district, there are a large number of agencies currently operating under Chapter 143 of the Local Government Code. What you're looking at in this bill is identical to Chapter 143 of the Local Government Code. It doesn't change anything for Fort Worth officers. It doesn't change anything for Austin police officers. It doesn't change anything for El Paso or the cities that are currently operating under Chapter 143 of the Local Government Code. For decades, they have enjoyed exactly what is on this bill right now. It doesn't change anything. What this does is it extends that Chapter 143 confidentiality that these other agencies have across all law enforcement agencies. The reason Dallas is unique, and they're not the only ones, but they're one of few, is that they have charter civil service. Because agencies who don't have civil service, there's a reason for that. Because you can only get it through an election, which is extremely difficult. It's a grassroots effort, very difficult to get. So what a lot of cities do is they take Chapter 143 and they get it, they put it in their charter, like Dallas, or they put it in their ordinances or policies so that they can mirror what is the gold standard for law enforcement, which is Chapter 143 of the Local Government Code, or what we call civil service. In this case, when you do put Chapter 143 into your charter to avoid the election, there is one provision that you cannot move into your charter, and it is this. It's the provision on personnel files, and the only reason for that is because Chapter 552 would supersede a charter. So that's the predicament that they're in, and they're exactly right. One of the reasons that we believe this is extremely important, not only for personal information that gets leaked out plenty of times, even in the Chapter 143 cities, which is why the model policy was developed to ensure that agencies are separating the information properly. We also feel strongly that the unsustained complaints, which again, reminder, Houston, Dallas, Fort Worth, Corpus Christi, are already have exactly what's in this bill. They already have confidentiality on unsustained complaints. Unsustained complaints, also memos, training memos, the way that we develop officers, every conversation that a supervisor has with their subordinate, every system they have in place. I came from the Austin Police Department. We had a system in place, much like the system the lieutenant here was describing, where a software can identify problem officers. And it works great because, again, you're identifying problem officers in many cases, but in 90% of the cases, you're just reviewing what could be a problem, but it turns out it's not a problem. And that information should not be available through 552 to the public. Absolutely not. And it's not currently for thousands of peace officers. All this does, again, is extends that to all Texas peace officers. And that was the purpose of the model policy. The bill that you're looking at takes the second section of the model policy and codifies it. The first section of the model policy is already in state law. We did it in the T-Cole Sunset Bill, talking about the personnel file. It's verbatim, right out of 143-089 Local Government Code. Again, this does not change anything for thousands of peace officers. It has nothing to do with Morton. It simply protects the level of confidentiality makes it across the board the same for all Texas peace officers. Hopefully I clarified some of the issues.
Senator Hinojosa.
Well, then why can't we just mandate Chapter 143?
I would love to, 100%. In fact, we have a bill by Representative Mondo Martinez that would make 143 automatic in pot brackets of 25,000 and above. We absolutely believe that everyone agrees, and I know T. Cole's here as a resource, that Chapter 143 is the gold standard. It absolutely is, but it's difficult to come into. And you can, and the agencies that don't have it are mirroring it through other ways, policies, ordinances.
So if we mandate Chapter 143, then what's the point of this bill? We don't need it.
Well, we've tried to mandate 143 many sessions, and it's never gotten a hearing. So we would love to do that, and we have a bill for it. Would love to get a hearing on that. But what this does is this takes one provision. I think I got cut off. This takes one provision out of 143, just one provision, and applies it across the board to all Texas peace officers. Again, wasn't a problem 10 years ago. It's definitely a problem now. They're exploiting this provision. A lot of the media, members of the public, anti-police groups, and this information is being requested on officers that, again, wasn't 10 years ago. And this privilege needs to be extended to all Texas peace officers equally. It should not depend on which department you work for.
I think we can do that without distorting the whole process we have in place that we worked many, many years to get it just right.
And that's what, Senator, respectfully, that's exactly what this bill does. It takes 143.089. We put it in a model policy agreed upon by all stakeholders, sworn and non-sworn, so that all law enforcement would operate under that. And that's all this is. It's a mirror image of one provision in Chapter 143. That's what this bill is.
I understand that, but the answer to me is just adopt 143. And
Yes, I completely agree with you.
Senator Miles.
Yes, thank you, Mr. Chairman. Ma'am, 143, point of clarification, 143 covers an officer's personal information, correct?
Yes, to an extent. Yes.
Does it cover also, clarification, does it also cover their disciplinary file?
Only if it was an unsustained complaint. And it only protects them from 552, not anything else.
Right.
Not Morton, not Brady, and not SB 24 by Senator Huffman, not the...
Only if it's...
The prospective agencies.
Unsustainable complaint, right?
Only from 552. Right. Not from other law enforcement agencies, not from Brady, Morton, or any of those.
I'm with you.
Yes, sir.
So, those unsustainable complaints, Madam DA, is something that you would want to have when prosecuting an abuse or a violation.
But I think she's saying that under Michael Borton, which would be the Discovery Act in criminal prosecutions, that they would be discoverable. Is that what you're saying?
Yes, there's been instances.
Not under 140, you can discoverable, but not under 143.
There have been instances where the information has been basically and again, doesn't pertain to this bill, but I'll answer it. Yeah. An in-camera review can be conducted, as you know.
Yeah.
And yes, the information can come out. If the judge agrees that it is Brady material, it can come out.
And a pattern of behavior sometimes like that would, to your point.
But it's not under law.
The evidence
but it's not under law. You agree?
Well,
do you agree with me?
It's part of the Brady. It's part of Morton.
I'm sorry, Mr. Chairman. But that part is not under law, correct?
It's part of Morton. It has nothing to do with this bill. I can say that for a fact.
Thank you. Thank you, ma'am.
Anything more, Senator Huffman?
Nope.
Thank you. Any more questions? Chief?
Good morning, Chair and members of the committee. My name is Danny Kill, and I serve as the Chief of Police for the Jersey Village Police Department. I'm here today on behalf of the Texas Police Chiefs Association in full support of Senate Bill 781 filed by Senator King. 781 addresses a very real and growing concern among law enforcement professionals, the need to protect peace officers' personal and professional information from unnecessary and potentially harmful public exposure. Currently, whether or not a peace officer's personal information is protected, things like home, addresses, family members' names, and even internal documents depends largely on whether the officer works for a state or civil service agency under Chapter 143 of the Local Government Code. The reality is most cities in Texas have not adopted 143 protections, meaning many officers across the state lack basic safeguards that other officers already receive. Senate Bill 781 seeks to fix this disparity by codifying the Texas Commission on Law Enforcement's model policy and creating a confidential departmental file. This file would include documents related to an officer that have not already been housed in their personnel file. These records would only be accessible to hiring agencies and to TCOL for regulatory investigative purposes, preserving the due process while protecting the officer's privacy. As a police chief, I fully support accountability and transparency, but I also believe that officers deserve consistency and fairness in how their information is handled. If civil service officers are granted these protections, then peace officers across the entire state, regardless of their size or status of the department, should be granted the same. This bill doesn't weaken oversight, it strengthens trust both within our profession and between our organizations, agencies, and communities we serve. Thank you for your time and consideration in this bill.
Thank you, Mr. Any questions? Thank you very much for your testimony. Mr. Beauchamp.
Good morning, Mr. Chair, members. John Beecham, General Counsel, Texas Commission on Law Enforcement, here as a resource witness. I look forward to any questions you may have.
Members, any questions? Senator King.
Just to make sure we all understand what we're talking about. With this, well, first off, Section 143 applies to cities that have had an election. It establishes a state directed civil service system for whatever communities have adopted it. Like I said, Fort Worth has it, El Paso, Corpus Christi, Houston. I think there's I forget how many cities, Waco, Wichita Falls, Lubbock, 135 cities have adopted it. And they have the two file system, the department file and the personnel file. And this would set up that same system for every law enforcement agency in the state. So what would be in the personnel file and what would be in the department file? Could you just kind of clarify that? You
Certainly.
Or anybody?
Certainly, Senator King. The personnel file, which has been referred to as the 143A file, the personnel file has a very specific set of explicit express categories of information that is open to the public, whether at the agency or otherwise. It includes accommodations, substantiated instances of misconduct, and evaluations. That's the specific categories of information that are in the personnel.
Your training records would be in that as well, is that correct?
Yes, sir.
Okay.
Now, in the department file, which is referred to as the G file, as it's under subsection 143.089, that has your unsubstantiated instances of misconduct, everything that does not belong in the A file as according to the specific categories, the misconduct that's been proven, evaluations, accommodations, things of that nature. So there's a distinct separation between the two.
And so where is in which file would your wife's name and your children's name and your contact information and where you live, where would that be?
I think based on the character of that information that you just described and the information that belongs in the different files, that's the type of information that would probably not necessarily show up in an evaluation, substantiated instance of misconduct, or
that's going to be your department file.
Yes, sir.
All right, thank you.
And Senator King, if I may, I know there was a discussion earlier. I think it goes to Senator Hinojosa's question. What's different about this versus the way that the system is, the way it's been set up? I want to emphasize what Ms. Zamansky said earlier. Right now, departments who don't have civil service don't have this system set up in the way they keep their records. What this does, in accordance with the Sunset Bill for TCO last session, is it sets up that for all non-civil service entities, so that uniformity of record keeping in order to effectuate. This is the other side of it, the transparency, as Senator Huffman's bill 2 sessions ago, SB 24, requiring hiring agencies to look at both the personnel and the department file anytime they make a hire for a law enforcement applicant. So
And that remains in place.
Absolutely.
Could you also just quickly tell us what the process was for developing this model policy?
Certainly, Senator King. The model policies were brought together with advisory committees, 12 to 13 members each. This particular one related to personnel files. We had non-sworn, sworn from different types of agencies, different groups came together, met for a period over 3 to 4 months, came up with the model policies and presented them to the commissioners, TCO commissioners. It was approved. And has been set out as the model policy for the state for adoption by all agencies.
Okay. Thank you, Chairman.
Any more questions? Thank you all very much for being here.
Thanks, sir.
Thank you all very much.
So seeing no other invited witnesses on this bill, invited testimony is now closed. Chair now opens public testimony. The chair calls the following witnesses. I hope I pronounce this correctly. Mark Moonshine. That close? Moonising. Ananda Thomas, Kathy Mitchell, and Kirsten Budwine. Please state your name, your position on the bill, and you have 2 minutes.
My name is Mark Munasinga. My position is no on this bill. My brother was killed in Austin by the police in November of 2022. At the time, I was living in Dallas and received a call that there was a shooting at his house. On my drive to Austin, I found a press conference that the police chief held 8 hours after his death. In it, it had several false and misleading statements, including the suspect was a white man who was shooting into a neighborhood, and when asked if he was the homeowner, they denied knowing. They also said that aid was immediately rendered to my brother. When I arrived on the scene and identified myself as family, they wouldn't tell me if it was my brother or a white person. And for 2.5 days, we called every hospital and friend to try to locate him before we were finally informed. After gaining access to the Ring camera footage, we also learned he was denied life-saving aid. A female officer can be heard saying, "Let's take off the handcuffs and give him CPR." 8 minutes later, she said he stopped breathing. Let's take off the handcuffs to give him aid. Nothing was done, and he bled out on his porch. None of the officers who failed to render aid were disciplined, and the false statements were never corrected. How is this fair and transparent? This bill will keep files related to misconduct hidden from police oversight groups who provide objective reviews and provide recommendations. Not only do these groups provide a fresh perspective, they also are a tool to help support police departments respond to the public on meritless claims. I understand the concerns about releasing personal information and the challenges we face with lack of standardization, but we need to fix these issues, not hiding the files and limiting transparency and accountability. Please vote no on this bill and work towards a better bill to keep these personal police information private and allow misconduct-related items to be shared with oversight groups. Thank you.
Thank you for your testimony.
Thank you for being here.
Thank you.
Ma'am.
My name is Ananda Thomas, Executive Director of Act for SA Action Fund, who represents Bexar County. I'm testifying in opposition to Senate Bill 781. I support officer personal information being confidential, but this bill actually hampers police and jailer transparency under the guise of a way to implement Chapter 143 protections for officer personnel information. The representative from CLEAT references Chapter 143 as the gold standard for officer personnel records, but I know for a fact it's not the gold standard when it comes to civilian oversight or police discipline, which is why several cities have tried to opt out of it or parts of it through ballot initiative or contract negotiations. And I'm happy to chat with any of your offices further about this. The vague language of restricting officer personnel records with special mention to exclude disciplinary records and complaints filed against them for alleged misconduct from any person or agency can easily be interpreted to extend to district attorney's offices, the Texas Commission on Jail Standards, lawmakers conducting investigations into events such as the failed response at Uvalde, and police oversight departments, hampering their ability to carry out their duties. These persons and agencies are very different than the politically motivated journalists and activists mentioned by Senator King. Let me give some examples. In the case of Uvalde, each involved law enforcement agency could first determine if there was sufficient evidence to sustain a charge of misconduct before allowing material to be shared. This also extends to jails. In the case of Javonte Myers, who died in custody at Tarrant County Jail from a seizure disorder deemed a natural death, 2 jailers were later indicted for falsifying records about checking on Myers that could have saved his life.
Thank you very much for your testimony.
You want to go first? Okay. Hi, my name is Kathy Mitchell. I'm with Equity Action. And like the previous witness, we have been navigating the complexities of records sharing under 143 as a city, my organization and our city, for many, many years. Chapter 143 is indeed a barrier to sharing information about police conduct with any agency or person. That language, once you craft it into the law, is going to stand between you and information about police conduct where there was not a finding that sustained the, discipline. I want to be very specific about how that happens. Sometimes it's because it wasn't true. And this is the kind of information that, to my knowledge, has never been released about police. To your point, Senator, anywhere in the state, we already have, under Chapter 552, a large number of law enforcement-related exceptions. However, sometimes the investigation was incomplete. Sometimes there was no investigation and the question was passed to a supervisor who had a conversation, and that's basically as far as it went. Sometimes officer misconduct is discovered later by members of the public, not through a Public Information Act request, but by the discovery of cell phone video or in some other way. And suddenly the district attorney is facing a case where there was no misconduct found by the department, but there is evidence that something pretty bad happened. There is a case out of Dickinson that meets that profile. So you want to be very careful about any agency or person. We have lived with this in Austin, and it has taken us 20 years to create a very narrow channel for critical information where our oversight system determines that there was indeed evidence of misconduct and a policy was violated, but nothing was done about it. And that memo summarizing the facts of the case.
Thank you, ma'am. Thank you. Your 2 minutes.
Sorry.
Please proceed.
Dear Chairman and members of the committee, my name is Kirsten Bodwine. I'm a policy attorney with the Texas Civil Rights Project, and we're here in opposition to SB 781. We have some of the same concerns as Senator Hinojosa and Senator Miles. This bill promotes less transparency and accountability for officers who are supposed to be responsive to the communities that they claim to serve. Several major Texas cities like Houston, Dallas, Fort Worth, and Austin have police oversight committees created to enhance the public's trust that complaints of misconduct against officers are conducted fairly and thoroughly. These oversight committees are tasked with reviewing the facts and evidence pertaining to an incident or complaint against an officer. SB 781 will likely interfere with monitoring duties by limiting the type of information accessible to the monitors, leading to deficient investigations and making it harder to hold police officers accountable for alleged misconduct. Many of the monitors and boards mentioned were birthed out of demands from Texas residents for more police accountability and transparency. Police departments have a lot of discretion and power over investigations related to civilian complaints. This bill incentivizes agencies to make quote, make the determination that there is insufficient evidence to sustain a charge of misconduct, end quote, because the result would be that no civilian can access the documents related to the investigation of the officer. This is not a good look, especially since the public is already skeptical of the internal investigation process. Police monitors and the public as a whole should be equipped with all of the information they need to hold police officers accountable, and SB 781 undermines that. Thank you.
Thank you. Thank you all for being here. Thank you for your testimony. So the chair now calls Brian Crow, Faith Bussey, Amanda Rodriguez, and David Stout. So is this Mr. Crow? And I'm trying to see what, Amanda Rodriguez, David Stout. So I guess you were it. Please proceed.
Yeah, I think over the past couple of years, I've kind of...
And please state your name.
Oh, I'm Brian Crow. Mark's brother, Rajan Munasinghe, was a close friend of mine. Okay. So over the past couple of years, we've kind of learned what's available in terms of oversight when there is misconduct. And, it's good that there's interdepartmental kind of checks and this is available within the police. But we kind of discovered that there's no external oversight. There's no kind of civilian oversight. So in Austin, we worked to get that passed. And the concern is this bill cuts that out. It doesn't let the civilian oversight actually go and see kind of what's going on. They're mandated not to share the personal information. That won't get out there. Obviously, alleged misconduct that it hasn't reached the point of conviction. I think the challenge I have with that is there's the level that you have to hit to convict a police officer of anything is insanely high. All they have to do is think that it's justified. In fact, I think there is another bill up later today that basically adds another exception to that effect. Like if they just think it's justified, then they're immune from prosecution. And so sealing this there needs to be people who don't have the background of police officers who kind of, obviously most of them are really good, but if that's what you see day in and day out as criminals, you start to see a lot of that way. You start to see the world through that lens. And so you just need a different perspective in there to be taking a look at this so that there's a little bit of sunlight and disinfectant. So that's why I feel like, yes, let's protect personal information, but let's make sure that there's still a carve-out for civilian oversight.
Thank you for your testimony.
Good morning. My name is Faith Bussey. I'm speaking for myself against SB 781. I do appreciate Senator King's staff for being good listeners as I initially contacted their office concerning this bill because of the loss of my friend Mason Yancey, a Second Amendment advocate who died in the Tarrant County Jail over Christmas break. And I do respect Senator King's legislative and law enforcement careers and believe you have sincere, good intentions. I do not see that good intentions are always a good indicator of good outcomes. And the words on paper have meaning in the real world, and unfortunately this bill would have impacts beyond the bill's intent. The bill analysis claims that the purpose of the bill is to ensure that personally identifiable information, including family members of law enforcement, are protected and kept from public consumption. I 100% agree with that. I don't think anyone would think it was controversial to have that kind of a bill, and I did bring by language really late yesterday. I'm very sorry about that. But where this bill starts to fall apart for me is where it includes each license holder. That includes jailers. It includes files with potential misconduct under these same protections. And lastly, it ensures this misconduct file cannot be accessed by any agency or person outside of their department. Any agency or person means you. It means this body, lawmakers, could not know about potential habits of misconduct in order to improve the next response. It means the Commission on Jail Standards, who are tasked with creating standards for our jails. How are they supposed to do their jobs if they don't have access to those jailer files in order to make sure that what happened to Mason doesn't happen to anyone else? That means my pro-law and order Republican district attorney trying to prosecute criminals could not know how credible his law enforcement officers are in order to make his cases stick. If this bill were amended to address those two concerns, creating secret misconduct files and keeping them from any agency or person, I would be fine with it. Thank you.
Thank you for your testimony. Senator King.
Oh, thank you, and thank you for your very gracious testimony. I think, unless I'm missing something in this, I don't think this is going to apply to jailers. I think it's only going to apply to people who are licensed, commissioned peace officers in the state. I don't think it will apply to, and I understand what you're speaking about with the jailers.
Okay.
Oh, thank you. But I'm going to double check it and make sure I'm correct.
Thank you.
Thank you.
Thank you. Members, any other questions? Thank you very much for being here. Thank you for your testimony.
Very much. Thank you.
Thanks.
Chair now calls Lakshmi Fox, Christopher Harris, Bradley Hargis, and Morgan Shelburne. Thank you. We'll begin on my right. If you state your name, your position on the bill, and you have 2 minutes.
Good morning, members of the committee. My name is Lakshmi Fox. I am a God-fearing and law-abiding citizen, and I have only ever had positive experiences with police officers. All that aside, I do think that the public and the media and other agencies having the access to data about misconduct, whether it was sustained or not, is important because it is a deterrent against police misconduct. Currently, police officers with any kind of misconduct or termination can move on to any other jurisdiction and continue being officers of the law, even if they don't deserve to be. I am against this bill because it decreases public trust by reducing transparency between law enforcement and the citizens they serve. Thank you.
Thank you very much for your testimony. Please proceed.
So, we're hearing a lot of things from CLEAT and other law enforcement agencies.
Please state your name, please, sir.
Oh, I'm sorry. My name is Christopher Harris. I'm speaking on behalf of myself. Sorry, can I continue? Okay. So we're hearing a lot of things from CLEAT and other agencies about, that these files could be used against officers. They can say that, but do we know that has happened? And I submit to this committee that this has not only happened, this is happening against officers and defendants in trials. And I have information on that, lots of information on that, and records. And I have G files right here and how I got a hold of them. I do think that they should be open to some type of prescribed inspection by a Civilian Oversight Commission. I think that, that should be allowed. But at the same time, I do think there should be protections on this information because it's officers speaking against their own self-interest, basically. We're compelling people to speak, and we're telling them it's going to be confidential, and then we're coming back later, and we're saying, oh, by the way, that thing we said was confidential? Yeah, it's not confidential anymore. I don't know. Yeah, I guess that's where I'm going to go. I'm done.
Thank you for being here, and thank you for your testimony. Please proceed.
Good morning. My name is Bradley Hargis. I am the Executive Director of the Capital Area Private Defender Service. I am here to testify against Bill 781 for some very specific reasons. As the Executive Director of CAPS, we oversee indigent defense in Travis County, handling hundreds of thousands of cases over the last decade of clients who had to have court-appointed attorneys because they could not afford them. There is a very significant distinction between Senate Bill 781 and the Occupational Code. Senator Miles and Hinojosa were really spending a lot of time, and Senator Huffman acknowledged the importance of Brady. There is a protection in the Occupational Code that says unless otherwise required by law. There's 4-word difference between Bill 781 and the Occupational Code. 781 does not contain a carve-out unless otherwise required by law. I am worried that 781 as it's written would not necessarily be compliant with Michael Morton, would not allow district attorneys to continue to get access to this information. And I know many of you, I won't need to tell this because you're law enforcement or a former DA or a lawyer yourself, but no bill passed by this legislature or by this state can override a federal constitutional right, which is what Brady is. It is the right to the exculpatory and mitigating evidence. That must be disclosed to the district attorney and to the defense. Otherwise, it will result in unfair trials, violation of constitutional rights, and cases coming back. And I just want to point out that Supreme Court Kyle's case says that only the district attorney can make this determination. The courts and the in-camera review we talk about, that process must be preserved. That is recognized in the Occupational Code by those 4-word differences between Bill 781, and without those 4 words, 781 would create a constitutional crisis for our criminal justice system. Thank you.
Thank you very much for your testimony.
My name is Morgan Shelburne, and I have been a public defender for 6 years. I'm here personally to testify against SB 781. I used to practice in front of a judge who would get grumpy with us attorneys for treating jurors like mushrooms, meaning he didn't like it when we kept jurors in the dark and threw manure at them. And this is what this law does, keeps jurors in the dark. In my experience practicing in Travis County, 143 did limit prosecutor access to these types of files. We, as defense attorneys, would routinely request impeachment material. That's what we're entitled to under Michael Morton and under Brady. We would request that. District attorneys would come back and say, we don't have it. But as defense attorneys, we're interacting with the same police over and over. So we see cases where they have been dishonest, and that's documented, or have committed some other kind of misconduct. So we say, well, that doesn't sound right. We're going to try to subpoena those records. We subpoena them, and an attorney for the city comes to court to try to quash that subpoena. So then we have a prolonged hearing in front of the judge. Then the judge decides whether or not they want to grant an in-camera review. At that point, the person accused of a crime does not have access to that material. Sometimes judges grant that review and they determine, yes, there's things in here that I believe that the defense should be entitled to. But it's too rare, and it keeps jurors and the public in the dark. So I'm opposed. Thank you.
Senator Hinojosa, you're recognized.
Thank you, Mr. Chairman. And I guess, I practice law both as a prosecutor, and I've defended police officers for police abuse. But I've been on both sides of the coin, so to speak. So the request for in-camera review is discretionary in the court. I mean, right now it's not mandatory.
Correct, yeah.
But does it require the judge, because I don't really recall, to at least look at the evidence and the judge decides whether or not to allow the evidence to be used?
In my experience, that requires some advocacy, right? So it requires the defense to say, we have reason to believe that these records do exist, and for some reason, law enforcement isn't handing it over to the district attorney's office or us. And in order for the defense to present that reason, we have to do independent investigation. But if these records are sealed, we're not able to even know that we're missing something. So it is a very difficult process. Yes, judges can exercise discretion. If we're not able to support our allegations that we think evidence exists and that we're missing it, then a judge can deny that request.
You have to provide prima facie evidence, at least.
Correct.
Senator Miles?
Mr. Chairman, can I take a minute of personal privilege? Just a minute.
Yes.
I want everybody in this room to understand I support law enforcement. I'm a graduate of San Francisco State University, law enforcement police science with honors. I got my T-close from Texas A&M. I'm a member of ALE, fraternity, police fraternity at San Francisco State. I filed 3 bills my freshman year. Opposite of Senate Bill 860, opposite of Bill 781, and also a bill to protect law enforcement and firefighters in the line of duty, killed in the line of duty, that their kids will go to a state school free of charge. And also a bill for Civilian Review Board with a subpoena, Mr. Chairman. My freshman year, Mr. Chairman, I had police officers come into my office and threaten me, telling me if I didn't withdraw those bills, that they may find some baby powder or baking soda in the back of my car. My freshman year, Mr. Senator King, I filed a DOJ complaint. I filed a local complaint with that police department. I filed a complaint with the chief of that police department. And I also filed one with the courts in that particular county. I've got apologies from the mayor, the chief, the administrative judge, and a congressional person. I want to make it clear, I support law enforcement. But these bills, these particular bills, are not bills that I can support. Not because of the experience I went through, because they're just not right. And I know there's a lot of law enforcement in here. I just want everybody to understand, Boris Miles supports law enforcement to the detriment of his life and his political history, his political career. Thank you, Mr. Chairman.
Thank you.
Mr. Chairman.
Senator King, you're recognized.
Thank you. And I want to correct myself. You're right. This would apply to jailers. And thank you for making sure I knew that. And the words, unless otherwise required by law, I'll look at that because that may be a really, really good suggestion. And Senator Miles, I certainly have the highest respect for you and appreciate your comments.
Thank you.
Likewise.
And that's a reason for our committees, is to be able to hear these bills and to vet them and listen to both sides and hear what our witnesses have to say. And that's Senator King.
And if I may say, we started this process because last session we passed a sunset bill that said go out and make model policies. And this is one of the model policies that came out of that. And so I think this is kind of we're following up on that and trying to see which direction to go.
Thank you, and I appreciate and welcome all discussion and input as we move forward to draft good policy and
Thank you, Mr. Chairman,
legislation.
For that personal moment.
So, thank you very much for your presence. The chair calls Jasmine Smith, or Yasmin Smith. Did I pronounce that correctly? Yasmin.
Got it on the second try.
Thank you. You state your name, your position, and please proceed. You have 2 minutes.
For sure. My name is Yasmin Smith. I am a born and raised Austinite. I am the Vice President of Justice and Advocacy for the Austin Area Urban League. I am a local attorney, and I am representing the Urban Leagues of Texas. Whenever I start talking about policing in any of its formats, I like to make sure I start with, I am from a military and first responder household. I respect and honor the individuals that wear that badge with respect and honor. However, and because two things can in fact be true at the same time, we would be remiss, we would be foolish, we would be short-sighted. In fact, we would be, I would say, negligent if we were not to acknowledge the systemic issues and the historic harms that your constituents face. To do so would be a harm to your constituents, and to do so would be an injustice to the officers that wear their badge with that duty and honor. Do not let 781 shield bad actors that do not adhere to their sacred duty. There are transparent ways to protect personal information while not creating barriers for accountability. This is not one. I charge you to find a way that protects officers' PPI and transparent external oversight. No one is above the law. No one is above our societal covenant of not doing unharmed or injustice and unnecessary harm to others. To allow 781, to allow bad actors to continue, because we have seen G files where officers do, especially in Austin, that go from one place to one and it's never known and people say and whisper, and it's not until something grotesque happens that those things are uncovered. Do not let 781 jeopardize your constituents or erode the protections that our democracy affords us. Thank you.
Thank you for your testimony. Members, any questions? Senator Miles, do you have a question?
No, sir.
Thank you very much.
Thank you.
Thank you for being here. So the chair sees no more people wishing to testify in public testimony. Is anyone here who wishes to testify on, for, or against Committee Substitute for Senate Bill 781?
Yeah, go ahead.
Senator Hinojosa, please.
Yeah, I was going to ask that. I was hoping that Senator King leaves the bill pending so we get a chance to work out some of these issues.
Oh, absolutely.
That were brought up during the testimony.
Yeah, I certainly request that.
And somebody asked me what happened with my case defending a police officer. I would try a jury trial in federal court in McAllen, and the officer was found not guilty. So, you know, I have not prosecuted any police officers, but I was really working on both sides. You know, it's very interesting in the dynamics that we face in trying to come up with a proper bill. And I would like to also try to align Chapter 143 with what you're trying to do with Senate Bill 781. So there's some issues there with the Brady and Borden Act, and also with what we're calling camera review, how to strengthen that to provide some guardrails.
Yeah, I would, and I would ask that this be left pending, Mr. Chairman, and give me some time to go and see if we can't make this work in a way that everybody's pleased with.
Thank you. So seeing no other public witnesses on this bill, public testimony is closed, and Committee Substitute Senate Bill 781 will be left pending. Yes. Chair calls up Senate Bill 1637 and recognizes Senator King.
Members, this is another very simple and easy to work through bill. So, not good scheduling on my part, maybe. Thank you. It is a peace officer's duty to protect and serve their community. This means running towards danger and confronting individuals wishing, and by the way, Mr. Chairman, I believe we have committee substitute.
Senator Parker offers committee substitute for Senate Bill 1637. Is there any objection? Hearing none, the committee substitute is adopted. Please proceed to explain the committee substitute, Senator.
Thank you. Peace officers are trained to display their firearm, obviously when confronting an armed suspect or searching buildings, but also, and more importantly, in self-defense, or in defense of another person. However, in recent years, peace officers across Texas, including in Dallas and Bexar and Travis counties, have been penalized for this very conduct and charged with violating the deadly conduct statute while acting in the course of their duties. Passed to combat gang violence in the 1970s, the deadly conduct statute criminalizes reckless conduct that places another in imminent danger of serious bodily injury. Texas is the only state in the entire country with such a statute. Under this statute, a person is presumed, and of course a presumption is always something you have to overcome in court, a person is presumed to have acted recklessly if they point or discharge a firearm at or in the direction of one or more individuals or a habitation. The deadly conduct statute was never intended to be used against peace officers, and Senate Bill 1637 rights this wrong by preventing such abuse. Senate Bill 1637 creates an exception for peace officers from prosecution under the deadly conduct statute as long as the officer, one, was engaged in the actual discharge of their duty and reasonably believed the conduct was necessary or justified. And of course, this would always be based upon their training. This change is necessary to distinguish a peace officer who draws their firearm to uphold law and generally in ordering a criminal who uses a firearm in trying to facilitate a crime. A typical situation might be an officer may be searching a building where an alarm went off, and you're going to have your gun out when you do that. And you walk around the corner, and all of a sudden there's the owner of the building inside there that you didn't know was there, and you've got your gun drawn on them. Strictly speaking, that would be a presumption that you violated the deadly conduct statute. Or an officer in defense of a third party believes that this person confronting this third party may be armed, and they have probable cause to believe that. Circumstances suggest that. In safety, they are trained to draw their firearm in defense of that third party. When they do that, they would be presumed to have violated the deadly conduct statute and could be prosecuted as such. And so this creates an exception where it says if the officer was, one, engaged in the actual discharge of their duties, and they reasonably believe, to a reasonable person standard, they reasonably believe that the conduct was necessary or justified to protect their life or the life of another, or necessary to stop the facilitation of a crime. And the committee substitute simply removes the retroactive portion of this legislation and adds Penal Code Section 951 to the list of justified conduct of a peace officer, and that's the section that deals with arrest and search statute. And we have a couple of expert or invited witnesses here, Mr. Chairman.
Senator Hinojosa, you're recognized.
Thank you, Mr. Chairman. Let me just say, as I read the deadly conduct statute, I don't see anywhere the word presumption. It just says a person commits an offense if he recklessly engages in conduct that places another in imminent danger of serious bodily injury. And then, as I understand present law, a police officer being charged can have an affirmative defense. Can he not?
Well, the problem with an affirmative defense is you get arrested and then you go to court and have to prove yourself innocent.
Isn't that the process that we have in place?
I'm sorry?
That's the process that we have in place.
So, in any case, and first off, I believe that recklessness is presumed because the specific elements and provisions are namely reckless placing another in imminent danger of serious bodily injury, and recklessness is presumed if a person knowingly pointed a firearm at another, whether or not the person believed the firearm to be loaded. And I think that's where that presumption comes up.
Well, but see, what you're doing with your bill, by doing an exception, you're pretty much providing blanket immunity to police officers for this type of conduct. And I don't think that was the intent of the original statute. And that we provided police officers affirmative defenses that they can use to defend themselves. As it is, it's very difficult to convict a police officer because juries will give the police officer every benefit of the doubt. So I don't. The other issue is, I guess, on the prosecution side, you would have to almost disapprove every single element on your special exceptions that you're providing for the police officers.
So,
what I'm saying is that having the exception that you have in your bill, Senate Bill 1637, pretty much provide blanket immunity police officers. Where the DA, they wanted to prosecute, they have to prove beyond a reasonable doubt every single element that you're accepting to be able to get any type of conviction. But that's almost very near impossible to do.
I guess my response would be, my understanding is that the bill does not change what qualifies in any way as deadly conduct. Rather, it creates an exemption from prosecutions for peace officers who are performing their duties. And an example again would be that where that police officer today, where that police officer draws their gun, turns out not to be a crime being committed, not to be a crime not being committed, but again, the perfect example is you're searching that building and you don't know that the owner got there before you did when that alarm went off and they got called by the alarm company, and you're in that building and you've got your gun and all of a sudden you see someone in there and you point your gun at that person. That's presumed to be recklessness and placing another in imminent danger of serious bodily injury. And under the current statute, you would, and officers are being charged. And we're simply saying, wait a minute, you didn't commit that crime, you didn't commit deadly conduct if you were in the performance of your duties and you were acting in a reasonable manner. In other words, following your training.
I guess I disagree with your interpretation. You know, I don't think pointing a gun is deadly conduct on the part of a police officer. You know, it's there's no doubt that our police officers face danger and risk their lives every day, and we get the best, and they sign up to be a law enforcement officer because they know they're going to be in danger. They know they're going to have certain risk. When I volunteered for the United States Marine Corps in Vietnam, I knew I was going to possibly get killed and possibly not come back alive. You know, but we also prosecuted soldiers, American soldiers, who, quite frankly, can't remember the name of the captain or lieutenant in the Army that murdered and massacred all these Vietnamese people. My point is that we have to have some type of guardrails. I just think that by your bill, you're removing the ability of a judge or a jury to make a decision based on the conduct of a police officer. That's a system we have in place. A police officer can, will the police officer go through some stress and pressure because the police officer is not guilty? Of course, you know, that's going to happen. It happens in the profession. They didn't sign up to play tiddlywinks. You know, they signed up to be in an area that was their danger in their lives. I mean, and protecting their families. So I just don't think you build good public policy by doing an exemption. We have sufficient protection by allowing for affirmative defenses that they can use very effectively to shield themselves.
I think we'll have testimony where, as to cases where officers have been charged for simply drawing their weapon in accordance with their training and performance of their duties. And I think that's what we're trying to do, is say when that occurs, you're not breaking the law. And you got to show that you were performing your duties and that and meet the proper standards of conduct.
Well, of course, they're performing their duties. They're out there. You know, so anyway, I guess we just disagree on the approach.
Senator Miles recognized.
Thank you, Mr. Chairman. Respectfully, Senator Hinojosa, I have to disagree. And Senator King, this is a great bill because we have to find a balance. We have to find a balance to protect our police officers as well as protecting our citizens. And it's a fine balance, but we have to find, as you said, Senator Hinojosa, those boundaries and those guardrails. So I commend you on this bill, Senator King.
Thank you, Senator. Any other questions? So invited testimony on committee substitute for 1637 is now open. The chair calls Robert Leonard and Jerry Staten. Begin on my right. Restate your name and who you represent and begin your testimony after you drink your water.
Thank you, Mr. Chairman, Senators. My name is Robert Leonard. I am the Executive Director for the Combined Law Enforcement Associations of Texas, commonly referred to as CLEAT, and I am here to speak in favor of Senate Bill 1637. With all due respect to Senator Hinojosa, I think that if you read A and C of the statute as it currently reads, there is an automatic presumption that if a peace officer were to point their weapon at somebody during the course and scope of their duties, they would in fact be in violation of this statute. I think that the most important thing that we have to get out before this committee here today is the fact that this does not exempt or carve out peace officers from the statute. It is simply a clarification of when a peace officer acting in the course and scope of their duties and with a certain degree of reasonableness based on their training and the circumstances that they find themselves in at that moment are not automatically presumed to have violated this statute. That is the most difficult thing that we have with this Penal Code 2205, in that it automatically presumes that an officer has violated the statute. If you read A, which says a person commits an offense if he recklessly engages in conduct that places another in imminent danger of serious bodily injury. And then you read C, recklessness and danger are presumed if the actor knowingly pointed a firearm at or in the direction of another, whether or not the actor believed the firearm to be loaded. That is an automatic presumption based on the statute. We are asking the committee to pass this bill with the understanding, again, that it is not a carve-out or an exemption from peace officers. Rather, it is a clarification. It is a redefining of what an officer's actions are based on a reasonableness, which is then based on their training and the facts and the circumstances that they find themselves in at that moment. I think Senator King, who we thank for carrying this bill forward for us, did an excellent job in stating that you cannot perform your duties as a Texas peace officer in this state without violating this statute at some point in your career. You are trained by your departments, by your academies. Your policies and procedures allow you to engage in the very conduct that this statute says is a felony. This language is necessary. As Senator Miles pointed out, it is a good bill. All it does is clarify and explain that a peace officer may find himself or herself in a situation where they may have to draw their firearm and point it at somebody, even if ultimately that person ends up being an innocent bystander, a person who is not the subject or the suspect wanted in connection with a crime. Sometimes that happens. But we have to understand that a peace officer is acting on what they know in a split second. They're basing it on their training. They're basing it on their policies and procedures. And as I stated, you cannot be a peace officer in the state of Texas and go to work for 25 or 30 years and at some point in your career not violate this statute. We are asking this committee to pass out this bill and offer your support.
Chairman, just a quick question.
Senator Hinojosa, you're recognized.
Thank you, Mr. Chairman. I guess my concern with the bill itself is the exception, and it's a carve-out. You can use semantics and whatever it is, but it's a carve-out, an exception, versus affirmative defenses. Because right now we have affirmative defenses can be used, and yes. It may be that an officer during a 25, 30-year career at some point pointing the gun at someone, but I don't think that prosecution, DA is going to be prosecuting them for that. So it happens sometimes, probably, but that's why we have the affirmative defenses. That's my main concern. I don't quarrel with some of the other points you made. I understand the dangers and the responsibility and the power and authority we give our police officers. It is a heavy one. But to me, I'm more focused on the exception carve-out, versus the affirmative defenses we presently have in law.
The problem with that, Senator, though, is that an officer would have to be indicted and their lives basically turned upside down and sometimes even ruined before they were able to exercise those affirmative defenses at a trial. We're here today to try to prevent officers from being unnecessarily indicted or prosecuted. Unfortunately, today we have a lot of district attorneys, activist district attorneys who have campaigned and gotten themselves elected on the predicate that they are going to go after police officers and prosecute, if not persecute police officers, in order to support their campaign promises to their constituents. In this case, this does not carve out an officer. It basically says that if you are acting in the course and scope of your duties, and if you weren't, that means that that section doesn't apply to you. It also says that you have to be acting reasonably. And if you were not acting reasonably under the circumstances, again, you're not carved out from this statute.
So you're taking away the ability of the jury or a judge to weigh the facts of the case.
No, sir, I disagree. I think that if a district attorney has enough evidence to put the case before a grand jury, then they will do so. However, based on the statute as it is written, a district attorney is almost compelled to put an officer before a grand jury based on A and C when read together. You can absolutely see this being abused and misused. That is the problem that we have with this statute as it is written. We are starting to see situations where district attorneys who in the past would argue that there were several statutes that could be applied to a alleged misconduct, murder, manslaughter, reckless endangerment, criminally negligent homicide. There are several statutes that would be applicable to the use of deadly force if the district attorney's office believed that an officer was acting against the law. However, in this particular statute, there is an automatic presumption that the officer has committed an offense. And I think that this amendment to the statute would help in the fact that officers would avoid unnecessarily having to be indicted. We have several examples where officers are indicted only to have those charges dismissed against them years later. However, when they're sitting there unemployed, unable to support their families or pay their bills, they are basically forced to, their whole life is upended because of a
we understand that.
overzealous prosecutor.
I don't see it as rampant as you look at this issue. I don't think it's rampant all over the state of Texas. Prosecutors are usually very, very conservative. You may have a couple of outliers, but I just want to look at how difficult you make it if this bill passes to be able to prosecute versus the affirmative defenses versus covering out this exception. And we'll have a resource witness from the DA's office hopefully here to be able to at least explain some of those issues. But thank you for answering my question, sir.
Please proceed.
My name is Jerry Staten. I am a retired police officer. I'm also a Vietnam veteran, and I am 75 years old, and I've spent 50 years of my life involved in the law enforcement arena. I have passed out my CV because in order to offer an opinion as an expert, I have to first prove that I am one, which I've done numerous times in court cases around the country. I'm going to have to disagree with what Bob said. He said in a 25 or 30-year career, a police officer may end up having to do this. No, a police officer is going to end up doing this basically once a week. And that's just, that's from my experience and my training. So training is my background. That's what I've done. When I retired from being a police officer, I went into my own training and have been training police officers for over 20 years, primarily on use of force. Now, the reason I said I disagree with him is because I don't know exactly how often any given police officer is going to have to draw a weapon and point it at someone, but it happens every day, many times a day here in Texas. And I want you to understand we're not just talking about the firearm in the traditional sense of a handgun or a shotgun or a rifle. Any weapon system that launches a projectile with gunpowder is a firearm. So if I point a less lethal shotgun at you as a police officer, I am in violation of this statute. If I have one of the new tasers, which is going to be, which they're already out there. There's 100,000 of them already on the street, which are going to be firearms because they launch with gunpowder. Then I can't point even my less lethal weapons at you without violating the statute. Here's my real problem. I have not been asked to come up with a training program or a policy that would allow police officers to do their job without violating this policy. But if I were asked to do that, I could not do it. And I thought, well, maybe I'm just looking at this wrong. So only had a couple of days' notice that I was going to be here. I called a number of known national experts on use of force and asked them the same question. If I was able to have you come up with a policy and a training program to teach police officers how not to violate this policy and still be as safe as you reasonably can be, without exception, every single one said, it's impossible. Those are juxtaposed. They're 180 out. Police officers have to be able to, at times when the situation is justified and reasonable, have to be able to be ready to use force when necessary, and that includes less lethal force. It's a firearm. I just, until I sat and listened to what happened before I came up here, I would have thought this was an easy one. How could anybody be against a policy that would set up a police officer to fail because he can't do what he's been trained to do? I just don't see the other side of that argument. And Senator Hinojosa, I no doubt you have an issue with it. It's impossible to juxtapose those two issues. They're too far apart.
I don't think we're trying to set up a police officer for failure. We're not doing that at all. We're having a discussion in terms of public policy, how to proceed, how do we provide the proper process to be able to deal with this issue.
Yes, sir, I agree with you.
Anybody's trying to set up a police officer for default or for failure.
Well, I agree with you, but it is my opinion as an expert that we can't do that. Those two, the Graham standard, and I don't want to go too far down that road, but the standard police officers are taught to adhere to are diametrically opposed to 2205. You just can't. You can't marry them. They won't fit.
Members, any questions? Any questions? Thank you very much for being here. Members, we have to be on the floor in about 6 minutes. So if it's okay with you all, we will stand in recess until after the Senate adjourns and then conclude our business this afternoon.
Thank you. Thank you, Mr. Chairman.
Senate Committee on Criminal Justice will resume our duties. So the chair now opens for public testimony on committee substitute for Senate Bill 1637. The chair calls up Mary Elizabeth, Shannon Edmonds, Mark Moonshine. I keep on messing up your name. I apologize. Is it Moonish Singh? Yeah, and Mitchell Masarijian. Yeah, close. Close.
Not as cool as Moonshine,
though. Yeah. Well, sometimes that comes to my mind. So, Mr. Edmonds, we're going to start with you first. If you would, please, just state your name and who you represent. And
thank you, Mr. Chairman and members. My name is Shannon Edmonds with the Texas District and County Attorneys Association, here testifying neutrally as a resource to answer any questions you might have.
Senator King or Senator Hinojosa, which one's ready? Senator Hinojosa, you're recognized.
Thank you, Mr. Chairman. I just walked in, so let me try to get my notes here together. But I guess we're on Senate Bill 781, Mr. Chairman?
1637? Is that what we're on? 1637.
And I was walking here as fast as I could.
Well, you did well.
Here's, I guess, one of the issues that come up during the conversation earlier this morning, and I know we're trying to work and resolve this issue, and that is dealing with an affirmative defense versus an exception, yeah, which is a carve-out. So what's the difference in terms of a prosecution trying to prosecute the type of case?
Sure, we have many more defenses than exceptions. There are about 24 exceptions in the penal code out of about 300 crimes. And the difference, the burden on a case involving a defense is always still on the state. But the difference is that if it's a defense, that is only triggered when there's some evidence raising the defense, like self-defense or an age, Romeo and Juliet age. So that only happens if the evidence in the case raises that issue, whereas an exception applies to every charge of that offense, regardless of the facts in the case. And the state has to put that negative in the indictment and disprove it beyond a reasonable doubt, whether it's raised by the evidence or not.
It's each element.
Each element, yeah.
And I know we're trying to work on some language. Senator King. Senator King.
Yes, I'm listening and reading.
Yeah. So try to zero in and focus on what the problem is with the presumption. That really seems to be the main issue. But that was the main concern, because I know I had a bill that we had a hearing here where this same issue came up in terms of an exception versus an affirmative defense. But I just wanted to go ahead and reaffirm the issues that are involved when you try to prosecute someone and setting out the differences between those two. But that's all the questions I have, Mr. Chairman. Thank you.
Senator King?
Thank you, and thank you, Senator Hinojosa. So, if an officer is arrested on a charge, and maybe deadly conduct is a lesser included offense.
Can be.
What is the burden of proof for an affirmative defense?
So in affirmative defense, the burden is actually on the defendant in criminal law.
Right.
But that's a least
protection. Does he have to prove that beyond a reasonable doubt?
By a preponderance.
By preponderance. And so you could still have a situation where an officer is arrested and an information or an indictment, whatever it would be, and they're charged with deadly conduct, and then they're going to get suspended from the department, and they're going to file notice of the affirmative defense, and probably have a pre-hearing on that, pre-trial hearing on that, or would it be only proved up at trial?
It depends on what the defense is. So an example would be insanity is an affirmative defense. So the defendant his lawyer has to prove it.
What if, in this case, the affirmative defense would be I was a police officer doing what I was trained to do?
Well, and also, if I can clarify, there are three. There's an affirmative defense, a defense, and an exception, as they go up the rungs of the ladder.
So this is an affirmative defense. And so would that be brought up pre-trial, or would that be a pre-trial motion, or is that something that's going to only be brought up at trial after the prosecution rests?
It would usually come up in the trial if the parties weren't able to resolve it ahead of time. So some of these issues, some of our affirmative defenses, for instance, are based on age or a status, and if you can show the status, the prosecutor knows there's no point going forward.
And so, and that's been my concern through this whole thing is that if the officer didn't do anything wrong, but because of the presumption could be charged, and it would probably end up being out of some lesser included offense type deal. And, or just some prosecutor for some reason wanted to charge with that. And we also had that testimony this morning from the gentleman that said you could be using a less than deadly force shotgun shooting something, maybe at a riot situation or something like that, maybe tear gas or something like that, that pointing that weapon as well might also fall under this, and I actually hadn't thought that might be a possibility. But what I want to avoid happening is an officer getting charged with this, getting suspended, going a year or two without their pay till it finally gets to trial, and then they are usually broke by that time and can't afford a counsel anyway because they hadn't had a job. They lost their employment, or at least are on indefinite suspension. And then they go to trial, and then they've got to prove this up, and they prove up the affirmative defense at trial, and then, by then their life's pretty well ruined anyway. So that was why I went with an exception, because then it would say, they could still be charged with deadly conduct, but the prosecution is going to have to show that they were not acting in the course and scope of their duty, that they were actually committing the crime of deadly conduct. Then you suggested to me during the break, and I'd like you to speak about that a little bit, you suggested, what would happen if you just removed the presumption from the deadly conduct statute? And could you talk a little bit about what that would look like and whether that would affect both sections, the felony section and the misdemeanor section?
Sure. After the testimony earlier about the challenges that officers face with this presumption, we did mention that you can leave the presumption in there for non-peace officers, but there are examples in the penal code where you all have created a presumption, which is a way to help the state prove its elements, but then also said this presumption does not apply to certain situations or certain defendants. So you could, in this case, say that the presumption in subsection C that presumes recklessness or danger when somebody points a firearm at another does not apply to an officer who is engaging in that, course of their duties. And so that would mean the presumption would apply if I was being prosecuted for waving my gun at somebody, but not to an officer who's got the training and experience to know that they're not being reckless when they do that.
Okay. That's actually interesting. I think I want to kind of talk to some of the law enforcement folks about it, Mr. Chairman, but that might be an avenue we could go. That sounds like something that might satisfy your concerns as well.
I think it would be a much better approach to the situation we try to address, much more narrow, that applies to police officers, so there would be no presumption under this statute.
I'm not saying that I'd like to talk to the law enforcement about, see what they think, but I think it's something we probably need to discuss after the hearing.
Very well. Any other questions?
You got any other thoughts on this?
Yeah, thank you, if I may. The only thing to note about the exception, and you've been talking about affirmative defenses, but normally self-defense is a defense. It's not an affirmative defense. So the defendant doesn't have the burden to prove self-defense. If evidence is in the case that it may have been self-defense, then the state has to disprove that beyond a reasonable doubt. So the burden is still on the state once the issue comes up. The challenge with an exception, the way this was written, it may be too broad. We're having trouble figuring out that this may prevent the prosecution of cases not involving peace officers. So that would be one thing to tighten up. But also the way the standard is stated in the committee substitute on line 11 and 12, that the actor reasonably believed their conduct was necessary, justified, that's got two legal flaws in it. One of them is that reasonable belief is already in sections 931, 932, 933, 951. So this says we'd have to disprove they didn't have a reasonable belief, that they didn't have a reasonable belief, that it doesn't work legally in the charge. And the other problem with an exception versus a defense is that all the burden is on the state. The defendant doesn't have to say anything, and the defendant has a right not to testify against themselves. So disproving what their belief was when they can sit there and not ever say anything is almost a catch-22, that you can't overcome that when it's an exception related to their mental state. So that's why the other exceptions we have in law have to do with their status or their conduct, but not what they were thinking, because absent a confession, the state can never overcome that, and it's an exception. And I know that's kind of inside baseball, but that's the challenge there, that you could change it to a defense. You could change it. Another way to say is that it does not apply to an officer. That is actually treated the same as a defense. It's just exceptions are very unique and very powerful defenses that sometimes have unintended consequences beyond the ones you're trying to get to.
Any other questions, Senator King?
Oh, I was only going to say, so I've got some language here that you drafted up, and what this says is creates a C1. It says the presumption established under subsection C does not apply to a peace officer engaged in the actual discharge of official duty. Okay. I think I'd like to talk with some of the proponents of the bill and see if that might work.
Yes, sir. Well,
I'd like to obviously
we'll continue to hear from our
testimony on the
witnesses
bill, but
that have traveled a long way to be here
We're happy to continue to help however we can.
as we continue.
Chairman, if I may.
Yes.
And Senator King, and what I try to do, and when I approach this type of situation, I try not to take sides and just look at the actual public policy of what we're trying to do and solve the problem and not end up creating more problems. And I think Shannon articulated that much better than I did in terms of the issues that the prosecution will face in an actual trial, and that pretty much it would be giving up in charge of any police officer for any of this alleged criminal actions. But
got it. We'll see what we can figure out here, come up with a solution that
yes, sir.
does what needs to be done.
Any more questions for Mr. Edmonds? Ms. Elizabeth, you're recognized. And Mary Elizabeth?
Okay.
Here, state your name. For the
Thank
record
you. Yes,
and your
first name
position.
Mary, last name Elizabeth, and I have a middle initial M if you care.
Yes, ma'am.
And thank you for your time. I have no training in the law, but I consider myself a reasonable person, so I'm speaking from a reasonable person's point of view. I like the concerns and questions that Senator Hinojosa had this morning about the exception seeming like a blanket immunity for police or a carve-out that protects officers no matter what they do. And there was an issue of specificity about recklessness, I think. Now, some of this was this morning, and I don't remember all of that, but there was some discussion about the specificity of, or what defines recklessness, and, okay, pointing a gun at a suspect. What about having the gun unholstered but holding it down to the side, pointing it down? I mean, do these specifics matter? I got the impression they did this morning. The standard of necessary or justified. My reading of Texas history is that the deadly use of force has been justified for over 100 years. Especially when the suspect doesn't look anything like the officer, when that the officer is more likely to use deadly force when he and the suspect don't look much alike.
Thank you. So are you on for or against the bill?
I'm against.
Okay. Thank you. Thank you for your comments.
Thank you.
Mr. Munising.
All right, thank you. My name is Mark Moonsang. My main concern and opposed to this current format is that this bill reduces the requirement for police to need to identify themselves before being charged with deadly conduct by grouping sections 931, 932, 933, or 951 together on the same line. Imagine you go to bed and you hear someone downstairs. You grab your gun, and you run to your front porch. You begin yelling at the intruder. Please, get out, get out. If you leave now, I won't even call the police, just leave. Across the street, someone sees you and calls 911, saying the homeowner is outside with a gun and he's scared of something inside. A police car arrives without lights or sirens, and the officer hides 25 yards away. He doesn't identify himself as police. He yells, "Drop your," and before the word gun, he shoots you multiple times. In your final moments, you realize it was a police officer, and your last words are, "It wasn't me, it wasn't me." That is how my brother Rajan was killed on November 15, 2022. Had the responding officer identified himself before shooting, Rajan would have invited him in, and my brother would still be here today. As a father, a gun owner, and a proud Texan, I value my ability to protect my home from intruders. In that dire situation, I would expect the police to identify themselves and help me. Not only is it dangerous to the public, but also the officers who can easily be mistaken for an intruder if not made known. Officers who ignore the protocol to identify and recklessly take a life need to be held accountable. Deadly conduct is the appropriate charge, which will ensure they will never be a police officer or own a gun in the future, while sparing them from an extended prison sentence. Please vote no, or go back and rewrite this bill so that Penal Code 951 is on a third line item as an and not grouped with the civilian deadly conduct codes as an or. Thank you.
Thank you very much for taking the time to be here. Any questions, members?
Hello, Mitchell Massarajan. Thank you for having me. Here testifying against SB 1637. This is my first time speaking in this setting, and I'm not a polished orator, so I'd just like to tell a little bit about the story you just heard here about my late great best friend Rajan Munasinghe. Rajan was defending his home against an intruder. Police officer showed up and without properly identifying himself, shot Rajan in the back multiple times, killing him. It wasn't until Rajan was being handcuffed on his own driveway, that he realized that this was actually a police officer. Had Rajan known that this was a police officer, he would have warmly welcomed the aid of this officer, of this peace officer. I'm sure Rajan was praying for the help of a peace officer in that very moment. This bill seems to protect officers, young officers, maybe less experienced officers. But if I'm in my home and I'm not sure if there is someone entering to harm or help me, it puts the officer at risk and it puts myself at risk. I find it hard to believe that there's an education we can leverage and de-escalation training that we can put in place to try and accomplish the goals that this bill is seeking, safety for the officers. Rajan was an amazing human being. He was generous. He was hospitable. He was the founder of a company that was all about helping others. He's a humanitarian. Had this officer properly identified himself, we would still have Rajan contributing to the city, to the state, the country, and globally contributing. And we would have an officer that's not on trial at this moment. When an innocent life is taken, there must be accountability. Accountability is very important. Thank you so much.
Thank you very much for coming forward and giving your testimony. Members, Senator King.
Thank you. And first, it's a horrible situation you've described, and I don't know any of the facts other than what you've expressed here, but it's obviously a horrible situation. I'm so sorry for the loss. I did want to ask, what was the officer charged with? What's the crime he's charged with?
Deadly conduct.
Deadly conduct?
Deadly conduct.
Okay, thank you.
Any other questions? Thank you. Thank you all very much for coming.
Thank you.
Chair now calls Ananda Thomas, Brian Crow, Kathy Mitchell, and Ruth Munasinghe. We'll begin on my right. After Ms. Munasinghe is set. Thank you.
Right. That's my right.
My right.
Good afternoon. Thank you, Chairman and committee members. My name is Ananda Thomas. I want to take a moment to thank Senator Hinojosa for his comments regarding this bill and Senator King's office for being so open to discussing amendment to this language. I believe this change in language is headed in the right direction, but I want to make it clear that I oppose this bill as it is currently written. Here is why. In Texas, discretion to take a case to a grand jury lies with the district attorney only. In a clear-cut case of officer defense of self or others, they can decide not to accept the case for prosecution and formally charge the officer, especially in cases where a firearm was simply pulled for, reckless endangerment. In fact, I've actually never heard of a DA taking such a case of an officer simply pulling their firearm in the line of duty to a grand jury, ever. But even so, after this, a grand jury would have to decide if there's enough evidence and question to warrant an indictment. Having tracked many officer-involved cases, this is already very rare to happen. I also want to point out that less than lethal weapons such as tasers can still be deadly, especially when used in a way that violates peace officer training or manufacturer direction, which should constitute a charge of deadly conduct. From 2010 to 2021, there were 513 cases where taser deployment led to a death, including the loss of a baby from a pregnant woman. The death of Norman Cooper in San Antonio resulted from officers tasing him a total of 9 times, with over a minute of electric current running through his body. This is why it is so important that we continue in the direction through these conversations to amend the penal code correctly. Less than lethal force weapons are still deadly and deserve to be looked at for a charge of deadly conduct.
Thank you for your testimony.
Thank you.
Hi, I'm Brian Crow. Just wanted to say thanks for considering an amendment to the bill. I think that it does sound like that will kind of address my concerns as well. I think at the end of the day, the real concerns are a blanket immunity doesn't allow for the discussion around the nuances where some situations do need to go to trial, do need to actually get taken into account. I think that the scenarios you're talking about of raising a weapon, absolutely, that's ridiculous. Cops should be able to raise their guns and not have to go through losing their job or anything like that. So striking that makes a lot of sense. I think that the other issue I am concerned about with it is if, at least as written, is around it being around your mental state and your belief that you're reasonably justified. Maybe there's nuances to that I don't understand, but it sounds like it makes it so I can just tell you, okay, yeah, I recently thought I needed to do that. There's, to my knowledge, nobody can commit a crime, kill somebody, and just say, oh, I reasonably thought I was justified in that, and get away with it. It just seems like a blanket, a way to get away with everything. And there is a high standard to convict police officers, which there should be, but we don't want to raise it so high that we start to attract the wrong types of people to become police officers. We want to be training people who want to look out for their community and help their community, not the sort of people who might have a penchant for violence and want to be in a position where they can be immune. So those are my concerns with it. It does sound like you're all thinking about it the right way with this proposed amendment, so that's great. Thank you.
And thank you for your testimony. Thank you for being here.
My name is Kathy Mitchell, and I'm opposed to the bill as it was before this discussion that I'm hearing today. I'm very heartened by some of the changes that are being discussed. I want to go through, what I think is the feeling of overreach that we have with the way that it's currently crafted. And that is that law enforcement's use of force is governed by 9.51. And the way that the committee sub, as a previous witness has said, kind of makes 9.51 an or in a list of various justifications, means that we're in fact expanding the footprint of allowable, justifiable use of force by law enforcement. And I don't believe that was the intent in this bill. The main expansion, of course, as was previously noted, is that under 9.51, as a condition of using force or lethal force, the actor manifests his purpose to arrest or search and identifies himself as a peace officer or as one acting at a peace officer's direction. You must manifest your purpose and identify yourself as a police officer. That's the floor. And the reason that that exists is because in Texas, the mere existence of a lawfully owned weapon does not create an immediate necessity for the use of force. That's sort of the ground we are all on with our gun laws. And so you've heard testimony from people who are gun owners who were not committing any crime. And we don't want to expand our use of force statute in such a way through the creation of this exception that law enforcement is no longer being held to that very minimal requirement that they manifest their purpose and identify themselves.
Thank you for your testimony.
Okay.
Ms. Munishing?
Good afternoon. I'm Ruth Munasinghe. I'm the mother of Rajan. I'm a retired public high school mathematics teacher. I'm also a nationally recognized educator. You know, officers shouldn't have immunity. They should have evidence-based de-escalation training and ongoing certification, like we do as teachers. That's my prayer. Today is my birthday, and I'm here to represent my son. He should have been here celebrating with me, but I know he would want me to help make sure this doesn't happen to another mother. Rajan was my baby. He was just 33. My son Rajan died due to an Austin police officer's deadly conduct. The trial is later this year. It's hard not to take this bill personally, as it could have impacted my situation. My son was a homeowner, a legal gun owner. He thought there was an intruder. He was standing on his front porch, facing into his house when the officer came in dark, silent, never identified as a police officer, and shot him to death. Rajan did nothing wrong. The officer was reckless. He failed to identify. He ambushed my son. He gave Rajan no time. If he had known the officer was there, my son would have put the gun down immediately and welcomed his assistance. Deadly contact is not the harshest charge that the officer might have gotten. We think it is a reasonable charge. The officer was clearly afraid. We know he did not get up in the morning expecting to kill my son.
Please continue your testimony.
But he was very reckless. If not, then what? Families like mine deserve justice. Please vote no for SB 1637 or just modify that. Thank you for your time.
Thank you for your time and thank you for your testimony, and God grant you peace. Any questions, Senators? Next list. Chair now calls Kirsten Budwine, Lakshmi Fox, Michael Bullock, and Morgan Shelburne. Kirsten Budwine, Lakshmi Fox, Michael Bullock, and Morgan Shelburne. So we'll begin on my right, and you may begin. State your name and your position on the bill.
Good afternoon, committee members. My name is Lakshmi Fox. I'm here representing myself, and I oppose SB 1637. Whatever the intention that this bill had, what it effectively does is reduce accountability of officers of the law. If officers are allowed to discharge their weapons without facing consequences in certain situations, this could lead to the misuse or abuse of force, especially if the situation doesn't clearly warrant deadly force. The concern is that if officers are given more freedom to use deadly force in their duties, it could contribute to an escalation in violent encounters between law enforcement and the public. This will undermine efforts to focus on de-escalation techniques and other non-lethal ways to handle dangerous situations. Laws like this will further erode public trust in law enforcement and decrease confidence in law enforcement agencies overall. Communities that are already disproportionately affected by police shootings could face more harm. SB 1637 could contribute to further harm to marginalized or underrepresented communities. I also want to give you some data about women and domestic abuse. An astonishing 40% of cops acknowledged in one U.S. survey that they were violent with their spouse or children in the previous 6 months. The second survey had similar results, saying that 40% of officers admitted there was violence in their relationships in the previous years, et cetera, et cetera. The point being is that there have been cases of police officers almost getting away with murder, and I extrapolated this to a potential case where a cop, a police officer, could carry out such a crime and then get away with it under the guise of being under duty. Thank you.
Thank you for your testimony.
Good afternoon now. Michael Bullock, and I'm the president for the Austin Police Association and representing the over 1,400 men and women of the Austin Police Department. First of all, I'd like to thank you, Senator King and Chairman Flores, for discussing this. I know it's not an easy topic. It is not an easy discussion that we are having because it does relate to the most serious aspect of the job and the oath that we swear to uphold as law enforcement. And that potentially involves the right of discharging a firearm if we deem it necessary. By no means does any officer believe that there should be a leniency or a lack of respect towards that authority, but the realities of what is going on it warrants discussion, and I believe this bill is necessary, and I do support it. Officers right now feel like they are stuck between a rock and a hard place, where oftentimes, well, in several instances we have had where officers have gone to trial and the state's own expert has said that their use of force is reasonable and they acted within best practice, national standards, and yet they were prosecuted. And we've had other instances where the department has said that the officer was justified, that the officer acted appropriately and within their training, and yet they have found themselves being on the other end of being prosecuted by the state, by the local prosecutor. So we're in this no-win scenario where officers feel like they have been given the responsibility of responding to extremely serious calls, and when they fulfill that duty, if it doesn't look good, if there is someone who does not like it, regardless of the facts of whether you followed your training and did what was appropriate, that you still could face jail time, you still could face prosecution. And that creates a great deal of uncertainty within officers, and it makes it even more difficult to do an already difficult job. We are certainly, like I said, not trying to expand any unreasonable aspect, but when you're deemed to have acted reasonably and still being prosecuted, it is extremely demoralizing and has a significant impact on officers.
Any questions, members? Ms. Budwine?
Good afternoon. My name is Kirsten. I'm a policy attorney with the Texas Civil Rights Project here in opposition to SB 1637. I do want to thank the author, Senator King, for the discussions that you guys were having earlier, but want to lay out some of my concerns as the bill is written. Police officers should be held accountable for conduct that rises to the level of deadly conduct. This bill would make it harder to do that by creating an exception. The bill analysis states that the original purpose of the deadly conduct statute was to combat rising gang violence and was never intended to be used against police officers. It is my understanding that prosecutors have the discretion to pursue charges when, one, they believe the person accused has committed the offense based on the evidence, no matter who that person is, and two, they are confident that they can prove their case beyond a reasonable doubt. This bill is being introduced in response to police officers who have been charged and are held criminally accountable for committing the offense of deadly conduct. Let's survey some of the type of cases that this bill would shield from liability. The first is former SAPD officer Oscar Cruz, who was charged with deadly conduct after yelling, "Stop running or I will effing shoot you," and then shot at a couple of teenagers who were running away from him. The second is former APD officer Christopher Taylor, who was charged with deadly conduct and found guilty by a jury after killing Mr. Da Silva, who was experiencing a severe mental health episode when shot. Mind you, this same officer was charged with the murder of an unarmed Mike Ramos just a year earlier. As the very first APD officer convicted of an on-duty shooting, Taylor is currently out on bond while his criminal appeal plays out, a luxury that most people accused of serious offenses do not have the privilege of experiencing. This is the type of conduct this bill is seeking to make an exception for, and for these reasons, we oppose this bill. Thank you.
Thank you very much for your testimony. Members, any questions? Thank you all very much for coming. Thank you for your testimony. Chair calls Yasmin Smith. Yasmin Smith. One more time, Yasmin Smith. If not, we show no more public witnesses. Is there anyone here wanting to testify on, for, or against Committee Substitute 1637?
Mr. Chairman, could I,
Senator King?
may I close on this?
Please, yes, sir. Recognize Senator King to close.
And I appreciate very much all the testimony that was here, particularly from family of people who have lost their life, and that's an incredibly difficult thing to do. And I want to be very, very sensitive to the situations that you discuss. And law enforcement is not perfect. There's no question about that. And I say that because when I was a law enforcement officer, I was not perfect. What I don't want to happen on the other side of this is I don't want officers to be afraid to go. I don't want officers going against the training that they have received and afraid to use their firearms and to display that firearm, because the intent of displaying that firearm is to stop a crime from occurring. Using it as deadly force is supposed to be always the very, very, very last resort. And I have no idea how many times in my years that I drew that firearm, but I've also been there when I've been there twice when officers were laid on the ground. One died from gunshot wound, and another one nearly died from the gunshot wound. And I've also had to go wake up a family in the middle of the night to tell them that their law enforcement family member had been killed in the line of duty. And what we don't want officers to do is become so concerned and so afraid that they don't use that firearm to protect themselves or to protect other parties when it is necessary. And that's that very difficult balance we're trying to get here. And so I very much appreciate everybody's testimony, and I appreciate the discussions from Senator Miles and everyone that spoke from the dais here today. And we'll try to work through this bill. I do believe something needs to change and needs to happen with regard to this statute. And Mr. Chairman, if you'll leave it pending, I'll see if I can't come up with something that is the best thing for the state of Texas over the next week.
Thank you, Senator King. I think leaving it pending is probably the most prudent thing to do. That way we can all work out something that's good policy and achieves the objective that you're seeking and as we move forward. So there's public testimony is closed.
Chairman, I just want to say a comment.
Senator Hinojosa, you're recognized.
Thank you, Mr. Chairman, and thank you, Senator King. I don't think anybody, any of us, doubt your sincerity. And our concern was providing blanket immunity to police officers. We understand what the problem is, but this is what's so good about these hearings, Mr. Chairman, that we get to discuss the pros and cons and actually have the witnesses come and point out some type of solution that we know or we didn't know. So I really like this process as it relates to try to pinpoint on the issue that we're trying to address. And I agree with you that there should not be a presumption against the police officers because the police officer has to draw a gun in a very risky type of situation. But thank you.
Thank you. We'll leave this bill pending.
Thank you, members.
Mr. Chairman, my light was on. Mr. Chairman.
Senator Miles, you're recognized.
I too want to thank Senator King for the consideration. And I too want to express my deepest sympathy for all the parents and brothers and sisters parents who have lost a loved one. But simply put, it's like I said earlier, it's a balancing act, and we've got to find a way to balance it. Law enforcement is a risky job. And police officers have to be protected as well. All police officers aren't good police officers. Majority of them, like I said earlier, are fine police officers. About 3% of them are turds. Just quite simple. And we have to learn and we have to defend and protect all of them. I thank Senator King for our conversation earlier, and I look forward to what comes out of it. And to the loved ones who've lost loved ones, it's a fine balancing act, and it's not perfect, but we're here, we're working to try to make it perfect. Thank you.
Thank you, Senator Miles. And again, it is the intent of the chair and the intent of the committee to draft good policy, good law, something that's workable, something that meets the objectives that Senator King is after, and that we all believe in. But at the same time, good policing, and as someone who's served 27 years as a peace officer and has had 3 line of duty deaths, that this is something we're very sensitive to. But the training in our state is some of the best in the world, and we always want to continue to make sure that training is adhered to, but yet at the same time, those that meet the 1% threshold of any population, that they are dealt with appropriately. Bottom line is criminal justice is about just that, justice, and the profession of policing is to serve and protect, And I think we all believe that. And as we move forward in drafting policy and statute, I think that's something we will accomplish working together. So with that, we'll move on to the next bill, Senate Bill 1321. The chair lays out Senate Bill 1321 and recognizes Senator Hagenbu to explain his bill.
Thank you, Mr. Chairman, members. Mr. Chair, members, the most important thing we can do, I believe, is keep Texans safe. And that requires that we have the very best people, best personnel in law enforcement. And that means we need to fully fund police and law enforcement and pay them appropriately. Today, I'm presenting Senate Bill 1321, a measure designed to enhance the recognition and support of our state peace officers by updating certain definitions and classifications within our government code. Section C is a classification on the pay scale used to compensate state employees. It outlines the salary structure for various law enforcement positions, including DPS, Texas Rangers, and other commissioned personnel. The Texas Commission on Law Enforcement, TCOL, has identified and brought to my attention certain peace officers on their staff that would benefit from being placed on that Schedule C classification. Recruitment and retention issues are plaguing law enforcement across Texas, and increasing these positions to a more competitive pay scale would greatly benefit law enforcement operations in Texas. This bill also adds peace officers from TCOL to the list of officers eligible for injury leave benefits and to expand hazardous duty pay and injury leave benefits to officers commissioned by TCOL. This was an exceptional item in the budget that TCOL requested and was granted already to them, and will affect 25 officers in the TCOL Oversight Division. Today I have Greg Stevens, Executive Director of TCOL, and Commissioner Jason Hester, I believe they're with us, yes, to answer any questions for the committee may have. Thank you for your time. Thank you, Chairman.
So this is a Schedule C bill? That's what this is,
Yeah.
Schedule C? Okay.
It's my understanding is oftentimes you do the bill and you get the funding, but the funding's already been approved for this.
I think we did that, Senator Hinojosa, in our work group. Yeah. So anyway, yeah, you're in good, Bill's in good shape, as Senator Whitmire used to say. So, any members, any questions? If not, invited testimony, Senate Bill 1321 is now open. You have Greg Stevens and Jason Hester. Identify yourself for the record, and you have invited testimony, so please proceed. Good to see you.
Good to see you, sir. Good afternoon, Mr. Chairman. Senators, thank you so much. My name is Jason Hester. I'm the Assistant Presiding Officer for the Texas Commission on Law Enforcement. I am one of the 9 appointed commissioners. I was first appointed by Governor Perry and then reappointed by Governor Abbott, so I'm in my 11th year as a commissioner, and so I'm here on behalf of our commissioners. This was an exceptional item for the agency, and Senator Hagenbuch, thank you very much for your work on this. And as he talked about, it is in the exceptional item and was in the introduced language coming out of the Senate. So for those of you on the committee, thank you so much for your work on that. TCOL employs a total of 25 peace officers, along with civilian staff that are responsible for the oversight and regulation of over 119,000 licensees and 2,800 law enforcement agencies. So what we're seeking in this legislation is to compensate our peace officers at a rate consistent with their peers at other state agencies by moving their classifications to Schedule C. I want to make clear this is not adding them to the law enforcement custodial officer supplemental retirement. So it is not adding them into the LECOS retirement. It is simply just matching them with Schedule C that is that is already afforded to investigators from the Attorney General's office and Texas Department of Insurance and other state law enforcement agencies. We have actually lost some of our investigators at TCOL to these other state agencies, and so by doing this, we hope that this helps us to retain those folks that we need. Our law enforcement and field services positions require significant previous law enforcement experience in order to carry out those duties. You really need somebody with that history and know how the agencies work. Typically what we get are those that have already retired and are looking to continue on, which has been worked well for us, but there's a finite window for that. And so we're hoping that by doing this that we can get more longevity in those staff that are working for us. Not a very, very large agency. Overall, the 25 peace officers that we have, we're hoping that this would greatly enhance our qualified applicant pool to be able to choose from, to choose the best to do the regulation and practices that we need for the Texas Commission on Law Enforcement. Be glad to answer any questions that you may have.
Any questions, members? Thank you.
Thank you.
Chief?
Good afternoon, Chairman Flores, members. My name is Greg Stevens. I'm the Executive Director with the Texas Commission on Law Enforcement. Senator Hagenbuch, I appreciate you carrying this piece of legislation. I'm really, as a resource witness here, I'll point out a couple of things. In hiring peace officers to come to work for TCOL, I think you can all imagine, I think all of you know, are pretty relatively familiar with what we do. It's a very unique role across the state when we look at our regulatory function with both the agencies and the peace officers, not just the 80,000 peace officers, but also the county jailers and the telecommunicators, total of about 120,000 licensees. We do a very unique function, and as Commissioner Hester stated, we've got to have people with a certain skill set and that are very experienced, that have certain things throughout their career. So it's already a pretty narrow pool that we can look for. And this is a unique individual, I think you can all imagine, that has to have that ability to sit across the table from a sheriff, from a chief of police, from a constable, and have difficult conversations when we do identify problems in an agency or with a licensee as we tackle the problem of the wandering officer that I've heard a lot of y'all talk about today. Again, I'm looking for very specific people, and I need to pay them at a level that I can bring in the very best of the best to accomplish our mission. And that's what I have for you, and I'm happy to answer any questions that I can.
Senator Miles.
Mr. Chairman, a question to both of these gentlemen, fine gentlemen. When you search out people to work for TCOL, You're looking for people who have a exemplary past. Is that? Could you agree with me on that?
Yes, sir.
Wouldn't you also recommend people to sit on your board as advisory to have exemplary past, just like your employees? Does that make sense? Just yes or no, sir?
Yes, sir. Yes.
Thank you, sir.
Thank you. Any other questions? I think you're in good shape, but thank you all for being here.
Thank you very much.
So being that there are no more invited witnesses, any more questions? No more invited witnesses are on this bill. Invited testimony is closed. Chair now opens for public testimony. We have nobody listed. Is there anyone present wish to testify on, for, or against Senate Bill 1321? Chair hears none. Public testimony is closed, and we'll leave this pending. We vote everything out here in a few minutes. With that, we'll proceed to Senate Bill 1370. Are you going to say, Senator Hagenbu? Are you going to be laying out Senator Parker's bill? Chair lays out Senate Bill 1370 and recognizes Senator Hagenbu to explain Senator Parker's bill.
Thank you, Mr. Chairman and members. SB 1370, medical examiner bill. Texas continues to experience rapid population growth, which has led to greater demands in county resources, especially in forensic services and death investigations. Under current law, only counties with populations over 2.5 million are required to have a medical examiner's office. As a result, mid-sized counties over 1 million in population but under 2.5 million lack the resources or the requirements to establish one of these. SB 1370 lowers the threshold from 2.5 million to 1 million, ensuring more counties are equipped to handle critical death investigations in a timely, consistent manner. The bill also clarifies that any 2 or more counties, regardless of size, can form a medical examiner's district. This allows counties to share costs, personnel, and expertise, which is especially important for meeting increasing forensic needs without duplicating services. By expanding the pool of counties required or that are able to establish an office and enabling multi-county cooperation, SB 1370 enhances investigative capacity statewide and bolsters public health, public health and safety. Thank you, Chairman and members. Ask for your support of this important bill, and happy to answer any questions. Well, not really.
Got a whole bunch. Members, any questions for Senator Hagenbu? So invited testimony of Senate Bill 1370 is now open. There's no one listed, so invited testimony is now closed. Chair now opens public testimony. There is one witness, Stephen Postilnik. I hope I said it correctly. Please identify yourself for the record, speaking to the microphone, and limit 2 minutes. Thank you for being here.
Thank you, Chairman and committee members. I'm Dr. Stephen Postelnik. I am the Chief Medical Examiner in Fort Bend County. I wrote this bill. This bill came to my attention in 2019. I am the first Chief Medical Examiner for Fort Bend County. We converted from a JP system to the ME system. I started the project in 2014. In 2019, the number was raised from 1 million to 2 million because Denton County wanted to avoid having to drop out of the medical examiner district that it was in with Tarrant County. They were very happy with it. They're in a district with Parker and Johnson as well. Over the years, I've had discussions with the folks in Denton. I completely support the formation of medical examiner districts because it is a moral imperative that as many citizens of the state of Texas come under medical examiner jurisdiction for quality of death investigation, for law enforcement, for the district attorneys. So you wouldn't want your appendix taken out by a psychiatrist. You wouldn't want your wife, mother, or child's breast biopsy done by an orthopedic surgeon. So why would you want somebody who's not trained in death investigation to investigate a family member's death? The bill started, this started out in Texas historically as 500,000 people and was changed back in, I think, the 70s by Brazoria County, who's nowhere close to 500,000. But it got raised, I think, for wrong reasons. And I've been working with Senator Parker's office to correct the number back down to 1 million. I am for this bill-ish. I can tell you that the rule of thumb is 100 per 100,000. That's the number of bodies that come to a medical examiner office, and it should be down that low. Also, I've been working with the JPs in Williamson County because they want to become a medical examiner jurisdiction as well. The one major problem with this bill is the requirement for the decennial census to be the benchmark of determining what counties must become medical examiner. The state pays for and funds the state demographer's office that come up with numbers that are scary accurate. When I first started in 2014, I looked at, they project out 14 years. Today's numbers, well, last year's numbers for Fort Bend County were off by the demographer's office back in 2013's predictions by less than 5%. So why don't we use them? It gives people 14 years to make plans. That's a better thing than waiting 10 years because that's a glacial speed of getting people under medical examiner jurisdiction.
Thank you. Any questions? Thank you for your testimony. Any questions? Yes. Senator Miles.
You're for, explain for-ish to me.
I personally feel we should be back, like I said, 100 per 100,000. We should be back down lower than 1 million. I know the support, it was 1 million. Everyone wants to go to that. But just imagine elected officials with no medical training handling 500 or 1,000 mysterious decedents per year. Waiting till that becomes 1,000 per county per year, you're still having justices of the peace investigate 950 strange deaths per year. I think that it really kind of needs to be lower than that, but as long as we get it off of 2.5 million, I mean, that's Dallas County.
Okay.
I mean, we shouldn't have Dallas County be run by justices of the peace.
Thank you, Mr. Chairman, because Fort Bend is my county.
Yes,
Chairman?
yes, Senator
So
Hagenbuch.
this is progress, though, towards what you would hope for.
It is certainly progress, correct, that my biggest...
The other thing is that by allowing counties to join up, it's possible that counties that have 100,000, like you're suggesting, could possibly combine and achieve, what you'd hope for, even though we may not be able to afford it.
That is going on right as we speak with Atascosa County and 4 other counties. I forget which they are, Kern and Wilson, something like that. I am assisting them in setting up their medical examiner district as well. They will number, that the whole district will number basically 300,000 people, but because of the paucity of medical examiners in the state of Texas, they want to try and recruit their own. So I'm doing for them what we did in Fort Bend County, and we serve 15 counties now for people who want to send us bodies.
And I represent Atascosa and Williamson, and so this is an issue that's important to both of them, and this does move the needle.
It's been a pleasure working with the judge and the DA and the Sheriff Soward as well.
Thank you.
I would like to, one last thing I'd like to say is there's a typo in the bill. Second to last line, you left off a 1 on one of the.
We'll make sure and point that out, and we'll maybe do a floor amendment to straighten the language. That's easily done. Any other questions? Thank you for being here, and thank you for working on this for us.
Thank you.
So seeing no other witnesses, public witnesses on this bill, is there anyone here who wishes to testify on, for, or against Senate Bill 1370? It's 1370, correct? 1370? Hearing none, public testimony is closed, and we'll leave this pending the vote. And at this point, I will pass the gavel to Senator Hinojosa, and I've got a couple of little bills there that are very quick.
Yeah, you just give me the gavel. All right. At this time, the chair lays out Senate Bill 860 and recognizes Senator Flores to explain the bill.
Thank you, Mr. Chairman. Members, the Criminal Justice Legislative Oversight Committee was created on June 15, 2007 by the 80th Legislature with the passage of Senate Bill 909 in Chapter 328 of the Texas Government Code. The committee was established along with other governing rules. Senate Bill 8680 abolishes the Oversight Committee since there has been no need for the committee in almost 2 decades. Is that not even met? So this is a cleanup bill. The Senate Bill 860 will remove other references to the committee in sections 493.027B and 508.114 of the Government Code. Section 493 contains management of employment rules for the Director of the Texas Department of Criminal Justice. Section 493.027B states that the Director must submit a report to the Oversight Committee. Since the bill will abolish the committee, there is no longer a need for this language in the section. Section 508 of the Government Code consists of management and rules for Board of Pardons and Parole, and Section 508.1445A contains the rule for the Board to submit a report to the legislature and list the Oversight Committee as one of the required recipients. Senate Bill 860 will remove the committee from the list and make the appropriate committees in the House and the Senate the recipient of the reports. The Senate and House have standing committees on criminal justice, corrections, and jurisprudence. These committees have jurisdiction for all criminal justice-related agencies. Therefore, the need for an oversight committee is not needed, which is probably why they haven't met in 20 years. So thank you for your continued support, and I'm happy to answer any questions.
Are there any questions of Chairman Flores? Chair is none. At this time, we'll open public testimony. We'll open invited testimony. And we have Marsha McLean as a resource witness. Or, are there any questions of the resource witness, Marsha McLean? I was invited. You gotta come here.
Marsha McLean, the Executive Director of Texas Civil Commitment Office, and I said, I believe I was invited as a ghost of committees past, and you and I know that. We spent a lot of years together between the TYC Oversight Committee and this Legislative Oversight Committee. And yeah, the funding went away, the need for the committee went away because of this committee, the Corrections Committee, and Jurisprudence.
Any questions? Thank you so much, Marsha, for your testimony.
We spent too much time together, you think, on these committees.
Is there any, I think that's all the invited testimony we have. At this time, we'll close the invited testimony. We'll open public testimony. Is there anybody present who would like to testify for, on, or against Senate Bill 860? Alicia Castillo, come on up. Just identify yourself and who you represent, and then you may proceed. You have 2 minutes.
Yes, my name is Alicia Castillo. I'm Associate Director of Policy at the Texas Civil Rights Project, and I'm here respectfully to oppose this bill. I recognize that it's been many years since the Legislative Oversight Committee was established and that there haven't been substantial meetings, but I don't think that means that we need to just abolish it. I think it means we need to outline specifics about the frequency with which this meeting should this committee should meet, because frankly the issues in TDCJ haven't magically disappeared because we have our once every 2-year legislative session, right? So these committees do incredibly important work for changing and making laws, but it is not the same degree of attention as a year-round oversight committee. And in a state that doesn't have any independent oversight over our prison system, it's really important for us to utilize any method of oversight we can. And so there were really legitimate reasons that the Sunset Commission recommended creating this oversight committee in the first place. And it just so happens that we haven't taken action on following up on what the Sunset Committee's recommendations were. So again, the lack of humane treatment at TDCJ, the deaths that continue at TDCJ, the lack of air conditioning, the nutrition issues, all things that we've highlighted and sent to your committee through our Sunset recommendations. These are issues that really deserve year-round attention. And so to genuinely address those, we would recommend that the committee remains in existence and actually begins meeting. Thank you.
Okay, Senator Miles.
So, ma'am, respectfully, you're saying that we shouldn't dissolve, but we should be spending more time on criminal justice issues.
Absolutely.
And
Particularly oversight for TDCJ and the prison system, which this committee was established for.
do we still have, just so I know, my edification, do we still have some prisons without air conditioning systems
We have a lot of prisons without air conditioning.
in the state of Texas?
Yes.
And Mr. Chairman,
Yes.
author, question to the author of the bill. Please.
Go ahead.
So you want to dissolve the entire criminal justice committee?
The committee is not, this oversight committee was established in 2007. and
I know that's been a long
basically hasn't
time ago. Hadn't
met 20-plus years.
you see no purpose for it, Mr. Chairman?
Well, this is a cleanup for, and so we have oversight. We have oversight.
We have oversight as a body.
And the Criminal Justice Committee in the House. I mean, we have oversight. Corrections and Jurisprudence in the House have oversight. So the report is still coming to us, and we can still require it to come to us. But this committee, in over 20 years, it's just there. And so this is so as a matter of cleanup, if you will. It's served no function. We have direct oversight over TDCJ.
So our oversight, does it also have teeth to make things happen?
Or is
it just an oversight committee?
We do. So when they do the report to us, and we have oversight over TDCJ. Plus, we make policy, we control the budget, and we make law. And so I think that's about as much teeth as you can get on overseeing an agency.
So if I can go back to the witness, what do you think we're going to lose? What, in your opinion, what are we going to lose?
Frankly, Senator, I think we're going to continue to lose lives. That's what's happening right now. And that issue hasn't been addressed necessarily in its, completely by these committees. And again, like I said, these committees were also in operation at the time that this was recommended. The legislature still operated 20 years ago, but the Sunset Commission did a review of TDCJ and said, hey, there are a lot of issues here, a lot of issues. One thing we would recommend is more independent oversight in addition to our bicameral legislative process that we have, right? So because these issues are so important, critical, and weighty, and you all have the task of establishing laws for this entire state in addition to managing, the basics around TDCJ. I understand that it feels like things are, we haven't ever met and things are okay. I would argue, and I think my friends who live inside TDCJ would argue that things are not okay, and we need a lot more oversight than what we have right now.
So they haven't met in 20 years. You want to start meeting again? Is that it?
I would love for the committee to start meeting. That's my request. That's TCRP's position, is that instead we would recommend, and we've recommended in writing to the Sunset Commission, to your committee in the past, that this committee, as part of this Sunset Review that is currently happening, should be included. We can clean up this, original bill from SB 909 in 2007 by amending it to say, hey, this committee should meet with this level of frequency, and here are the things that they should be taking care of. And those things should be directly related to what we see in the Sunset Report as issues.
So it sounds like the committee needs some oversight.
That's what we're here for. Recommend.
I would agree with.
Thank you.
Mr. Chairman, respectfully,
Thank you.
Thank you for your testimony. I don't think there are any other questions.
Thank you so much.
Is there anybody else present who would like to testify for, on, or against Senate Bill 860? If not, public testimony is closed. The chair lays out Senate Bill 1101 by Senator Flores, and recognizes Senator Flores to lay out the bill and explain the bill.
Thank you, Mr. Chairman. Member, Senate Bill 1101 deals with human smuggling. Is a heinous act that often leads to death. It affects every Senate district in some way. The amendments in the bill focus on expanding the definitions and conditions under which smuggling offenses are prosecuted. These charges can be levied in relation to the use of vehicles and other means of conveyance to support individuals with the intent to conceal victims from law enforcement or flee. So what this bill basically does, it was brought to me by the prosecutors in South Texas, that the bill provides clear legal definitions and strengthens the ability of law enforcement to prosecute individuals involved in human smuggling across parks and nature areas and open spaces. We didn't put it in last time when we dealt with this bill, with the Senate Bill 4, because it would have been to two subject rules, Senator Miles. So what we're doing is fixing it with this small adjustment that was brought to us by the prosecutors. So as they move across our parks, our nature areas, and open spaces, current law prohibits assisting, guiding, or directing two or more individuals to enter or remain on agricultural land without the owner's consent. I believe that was Senator Hinojosa, that was yours.
Yep.
So this expands the law to include the following: quote, cultural resource site or area, natural area, open space area, and park. And the terms have the meaning as currently defined by Section 24.001 of the Parks and Wildlife Code. So this is intended to protect these areas and ensure they are not used for illegal activities related to human smuggling. And with that, I believe we have a witness for us to testify.
Okay, are there any questions of Chairman Flores? If not, we'll open invited testimony and have John Hubert, Clarkburg County District Attorney, who worked with me last time getting the smuggling bill passed to make it much easier to be able to prosecute some of this human smuggling people.
Senators, thank you very much for having this bill. We really appreciate it. Basically, what we're looking at is the same problem with smuggling. It's like a balloon. When you squeeze it, it starts going out in a different direction. And so you've got to have more tools to address the issue. The human smuggling, as we know, is not only a danger to the humans, to the people living on the border, but it's also a danger to the people being smuggled. You can just pick up the newspaper anytime and see how people are left in trucks or left in the desert or left in these parks. These parks are huge areas. The Benson Park, where family groups have been known to be smuggled. The Azaldua Park. The Falcon Lake Park, where people drowned. These are incredibly dangerous areas. And it protects people that go in to want to enjoy these resources. Every tool y'all give us helps us chip away at the human smuggling issue. I believe that there was last session, or the session that we did the agricultural bill. Before that, what we averaged about 18 to 20 bodies that we'd find in Kennedy County per year. It has a population of a little over 380 people in the entire county. Yet we were finding people that were left in the ranches, just basically deserted. In Brooks County, there was 128 bodies or pieces of bodies found in 2012. In these vast areas, it's hard to patrol them. It's hard to do this. So when y'all pass this bill, when y'all passed the ag bill, all of a sudden we saw a reduction in the bodies we're finding in these areas. We're seeing a reduction in the trespass across the agricultural land. We're seeing a reduction in the property done to people that live in these isolated areas. And we're also seeing people feeling safer to live in the isolated areas, live in the rural areas, because we have some teeth behind it. So out of this bill, I would respectfully request that y'all pass it out of committee, but that it's done to protect the people that are being smuggled, it's protect the people that live and visit in these areas, and the cultural sites that exist, and the endangered wildlife and plants in those areas.
Are there any questions of Mr. John Hubert? I know we already covered agriculture, and we're dealing with a pecuniary exchange of money last time around. So now you're saying that they're smuggling people through the different parks?
Yes, sir. Depending upon what year, and the numbers fluctuate. I believe in, and I'm going from memory, 2021, 2022, there were, I believe, in Border Patrol, DPS had it as Anzaldúa and the Benson Park down in the southern part of Texas. There were about 1,200 families and family groups coming through there. This past year, I believe they had it narrowed down to 281 that they're finding so we know that a vast number is coming through there. This is not aimed at the immigrants. This is aimed at the transnational criminal organizations.
And this is my point. I don't mean to cut you off. So,
yes,
right now you don't have the authority to arrest a smuggler when they're crossing a park?
It's a criminal trespass. It's a Class A, it's a Class B misdemeanor is my memory, except under emergency powers, it'd be a Class A misdemeanor. So it wouldn't be a felony.
Yep. but you can, I guess, you can file charges against a smuggler who's smuggling involving human trafficking coming across while they're walking across a park. Right?
Yes, sir. That's what this bill would allow us to put teeth into it and to make it a felony where we could prosecute them as a felony. If they had a felony amount of drugs, we could prosecute them. If they endanger, under this bill, if they would endanger anybody under their care that they're smuggling across, we can heighten the penalty.
So it's an increase in the penalty by doing this bill, is what you're talking about.
Yes, sir. It would allow us to not only prosecute as a felony, but if they endanger somebody's life, if they sexually assault them, if they, all of a sudden, we prosecuted a gentleman by the name of Noe Miranda who sexually assaulted a illegal alien on a ranch. If he would have done, we could only get him for 20 years, but under the bail that y'all passed in the ag, all of a sudden, it's kicked up to where we could get him for a first degree with a maximum of 5 to 99 to life. This bill would add that same protection to people being smuggled across, but also it adds security to people that live and visit those areas because it'll reduce the amount of smuggling in those areas. It'll give us teeth.
Any questions? Well, thank you for your testimony, Mr. John Hubert. Good seeing you again.
Yes, sir.
Thank you for coming up here all the way from South Texas. It's always good to see you. And thank you
Yes, sir. Thank you.
for everything you do for Texas and protecting us.
I think that's all the invited testimony we have, members. This time, I'll close invited testimony. I will open public testimony. Is there anyone here present? Excuse me, I got two. Nick Hudson and Daniel Woodward. Daniel Woodward. Just please identify yourself, who you represent, and then you may proceed. You have 2 minutes. Go ahead.
Thank you, Chair Flores. Thank you, members, Acting Chair Hinojosa. My name is Nick Hudson. I'm with the ACLU of Texas. Thank you, Chair Flores. Your staff met with us about some of our concerns. I also was able to speak with DA Kleberg about them, too. When the legislature added 2005A3, when it amended that part of the statute, it did so without, in that sub 3, having a criminal intent requirement. And that's a safeguard that protects people from prosecution for accidental or innocent behavior. And as written, that section of code already mandates a 10-year sentence for anyone who assists, guides, or directs 2 or more individuals to enter or remain on agricultural land without the owner's consent. But because it doesn't require a showing of criminal intent, it would allow this charge to be pursued even if the underlying conduct does not have anything to do with smuggling, in fact. And this bill actually, because it includes public parks, cultural sites, natural areas, it means that someone could be charged with an offense across the state with a 10-year mandatory minimum sentence for something more akin to what might be a criminal trespass offense in a public park. And that broad expansion, I think, risks some unintended consequences of sweeping in conduct that has, again, nothing to do with human smuggling in any kind of way. A more foundational concern with the bill is that the public parks and open spaces are traditional public forums where people assemble and exercise their First Amendment rights. And so the particular way this bill is written, we think may criminalize protected constitutional activity related to speech, gathering in public parks. I think that good, judicious prosecutors won't use this against people who are not engaged in human smuggling. However, we've also heard today concerns about prosecutors who do not use their discretion in a judicious way. And so our ask is that we work on this to tighten the language and make sure that we're not sweeping in unintended behavior into the 10-year mandatory minimum.
Senator Miles.
So, sir, are you for, against, or on the bill?
We are against the bill.
Okay, thank you.
Yep, thank you. Sorry.
Good afternoon, Chair Hinojosa, Chair Flores, the rest of the committee. Thanks for the opportunity to speak today. My name is Danny Woodward, and I'm a policy attorney with the Texas Civil Rights Project, and I'm here to oppose this bill today. I'm going to make many of the same points as the gentleman before me, so bear with me. But right now, Section 20.05A3 of the Penal Code states that anyone who assists, guides, or directs 2 or more individuals to remain on agricultural land without the consent of the owner has committed a crime. and there are no other elements of this crime. If you ask someone what crime this was, they would probably say trespass. In fact, it's smuggling of persons, and there is nothing here about intent, concealment, financial gain, or any of the things we normally associate with smuggling. And for this, there is a mandatory minimum of 10 years. That means that according to the law as it exists today, I could drive two of my buddies onto ranch lands to have a few beers or whatever and end up in jail for 10 years. SB 1101 makes this worse by expanding the lands that are covered. So I could take my kids backcountry camping on a state park without paying the fee and end up in jail for 10 years. Most prosecutors probably wouldn't prosecute that, but that is what the law says. And I also want to note that there have been an expansion of arrests conducted with this statute. Most of that's been Operation Lone Star, but the demographics of those arrests might surprise you. 72% of people arrested are U.S. citizens, and most of those, or many of them, are teenagers who are recruited online to earn quick cash and drive someone from point A to point B. Often they don't know what they are doing, and they're subject to mandatory minimum in jail of 10 years. It doesn't deter them, but it does ruin their lives. So we oppose this expansion, and we would love to see you repeal the whole thing, but absent that, we would love to see a robust intent provision added to A3.
Are you saying that you go to a park with two buddies and drink beer and you'll be charged with smuggling?
That's the way this bill is written. And I want to be clear, not the way just this bill is written, that's the way the law is written right now.
But that's not smuggling.
I agree.
So, I mean, I don't see how you could, that's a key element of the legislation and the law.
Yeah, I think that's missing from the statute as written right now. And I think we have an opportunity right now, if we're going to revisit this, to add some protections into the bill. And we spoke with Senator Flores' office yesterday, and we're more than welcome to have that conversation.
Chair, can I call Prosecutor Hubert, John Hubert back up, and then we can ask some questions.
Yes, sir. Mr. John Hubert, could you please come up here? Any questions?
So, Mr. Hubert, so you're the one who actually prosecutes these cases that we're talking about here, and the one who brought this to us because it was problematic for you in your prosecution of smuggling cases. Could you elaborate to us? And from your
put your mic
side,
on, please. Sorry.
Your perspective.
At the first part of the section, it says intentionally knowingly do this. So it's not like you don't know you're doing it. We got to prove that. That's an element. Second of all, if you're out there camping with your kids, you're covered because it's within the second degree of consanguinity. If you're within the second degree of consanguinity, then it's not. It's basically a defense under the law. We're not going to charge anybody where we can't win. Second of all, the next thing is 10 years. Yes, 10 years is the minimum if you go to prison. You can also get probation. You can also get deferred. You have to use your common sense when you're a prosecutor. And there's a check on us. It's called the jury system. The jury system goes through and they decide if we're being overly ambitious, overly zealous, they can keep us in check. There's also the judges. The judges can decide if we're charging something that we can't prove. When the ag law came up, we were told we were going to hurt the Catholic Church, we were going to arrest nuns, the Boy Scout leaders would go to jail, all these kind of doomsday scenarios, and I haven't seen one yet. What I have seen is the reduction of the bodies that we found in the brush. What I have seen is the reduction of the property damage, people's hunting cabins or houses being burned, people's vehicles being stolen. So if we're looking at the actual effect of this law, I believe it's going to be to curb smuggling in those park areas. Again, if you're out there, one, you shouldn't be trespassing on government land. Two, if you're out drinking with your buddies on a ranch, that's probably pretty dangerous because they don't know you're out there because you don't have, and ranchers are scared. Why? Because they have human smugglers coming through doing nasty things. And when somebody runs through my gates and runs through my fences and leave trash all over the place and they're out there drinking, I don't know what they're going to do. I don't know if they're going to steal my truck. I don't know if they're going to break into my house. I've got a young daughter that's checking on things out at night by herself, checking on cattle. She now can't do that because she can't feel safe on the own place where she was raised. This is something that the agricultural law fixed. Now we're looking at people should feel safe in the parks, and we should get people from committing violent crimes. And I do consider smuggling a violent crime. It's run by transnational criminal organizations that are incredibly violent. They're doing it for the money. They're not doing it to help people out. They're getting paid a lot, and they don't care about the people they're smuggling. They only care about the payday at the end of the day. And so they leave them in incredibly harsh areas.
I think you answered
Be
the
heard.
question.
Sorry.
And Mr. Chairman, it was also with your amendment, I believe, it was to the third degree of consanguinity for human smuggling. It's
Well, yes, Your Honor.
to the third degree, not the second degree.
The third degree lowers it down to 5 years if it's a third degree, and we can prove that they were actually smuggling.
That's correct.
Okay, any other questions, members? Okay.
May I make something?
Just for the record, Mr. Chairman.
Yes.
Your intent of this bill is to reduce smuggling.
Absolutely. My intent of this bill is to reduce the scourge of human smuggling and what it does for human beings. And at the behest of the people who are prosecuting this on the front line, this is what he believes he needs, and other prosecutors need to be able to address this issue more effectively, especially when it deals with parkland.
And I think that's all we can all get behind and support that. And all three of y'all at this table are lawyers. Am I correct?
Yes, sir.
You're not?
I am.
Okay. It amazes me, members, that we can't, with all this brain power, we can't find a way to write this bill so that the intent is clearly written and we don't have mishaps where people who are just trying to enjoy a park get off track and wind up in somebody's property and possibly be arrested. Senator King, it just amazes me that we can't figure that out. I understand your problem, sir. I mean, I've been on deer leases down in Uvalde, and many times people have come down and terrorized our deer camp. So I understand that completely, but it just amazes me that we can't find a way to clearly write this law, this bill, that so it really just adjusts. It really is for the intent, pure intent of smugglers.
Well, may I respond?
Of course.
So, and thank you for that. I think I have I brought this bill forward with the full trust and confidence of the prosecutor on the ground in the front line.
Understood.
Who said, this is what I need, and brought me this language and said, this is what I need. And I said, well, if that's what you need, you're on the front line and you're there to help a human being that's being trafficked and smuggled and treated like baggage and garbage and just a piece of commodity. If we're going to address those people and make their life difficult, I don't believe that this man sitting right here or other prosecutors are going to go after a guy that's drinking beer on a park. I don't think so. That's a long. I was a lawman for a long time. I wouldn't. Come on now. Now, if he's out there being a coyote, that's a different story. But if he's out there just with his family and especially up to the third degree of consanguinity, he's not engaged in smuggling and trying to conceal and taking advantage. I mean, that's for gentlemen like this and others, ladies and gentlemen, in the front lines of our district attorneys that are out there as prosecutors to be able to prove beyond a reasonable doubt that they're engaged in that smuggling. And that's why I took the bill, Senator Miles.
Understood, Mr. Chairman. Understood.
Thank you.
That we can't write this bill with its clear intent.
Okay. Any other question, members? Thank you all for your testimony.
Thank you.
Thank you very much.
Thank you, sir.
Is there any, this is public testimony? Is there anybody else? This is, was this public or invited?
This was public.
Okay. I don't think we have any more witnesses, but is there anybody else present who would like to testify for, on, or against Senate Bill 1101? If not, public testimony is closed.
If we can vote out these two, or Senator, do you want to take the gavel and vote?
Doesn't matter. What are you going to do, Mr. Chairman?
Okay,
Vote out these two, and then we'll vote out the rest of them.
the chair, Senator Flores, moves that Senate Bill 860 report to the Senate with a recommendation do pass and be printed. Clerk, call the roll.
Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 5 ayes, 1 nay.
Being 5 ayes, 1 nay, Senate Bill 860 is reported to the Senate with a favorable recommendation. They do pass. Chair, this time brings out and lays out Senate Bill 1101. Senator Flores moves that Senate Bill 1101 be reported to the Senate with a recommendation do pass and be printed. Clerk, call the roll.
Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles,
No, I'm sorry.
No, that's all right.
Oh, we said 1101? I'm sorry. 1101 is a yes. I correct myself. I thought we were talking about Senator King's bill.
oh, okay. Senator King,
That's on Park right now.
Senator Hagenbu.
Please understand.
We pended that one. We pended that one.
Man, he's feeling love. I mean, I've been carrying that bill, opposite that bill,
So what's
for
the vote?
18 years.
19.
19.
Hold on, please. Okay.
6 ayes.
Being 6 ayes, no nays, Senate Bill 1101 reported back to the full Senate with recommendation to do pass.
Local?
Senator Flores moves that Senate Bill 1101 be referred to local. Is there any objections over that? If not, so ordered. All right. Going back to Senate Bill 860 that we just passed, Senator Flores moves the question that Senate Bill 860 be on the place on the local calendar. Is there any objection to placing that on the local calendar? I think you can't because you also no vote. All right. Would you leave it as it is, so we'll go to the floor.
Thank you.
Sorry about that,
All right.
Mr. Chairman.
So at this time, we will go to Senate Bill 693. So the chair calls up Senate Bill 693. The chair moves that Senate Bill 693 do not pass, but that the committee substitute for Senate Bill 693 be adopted in lieu there do pass and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 6 ayes.
There be 6 ayes and 0 nays. Committee substitute for Senate Bill 693 is reported favorably to the full Senate. Senator King moves that committee substitute for Senate Bill 993 or 693 be referred to the local and uncontested. Any objection? Hearing none. So ordered. The chair calls up committee substitute Senate Bill 836. The chair moves that Senate Bill 836 do not pass, but that the committee substitute for Senate Bill 836 be adopted in lieu of and do pass and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles,
Aye.
Senator King, Senator Hagenbu.
Aye.
6 ayes.
Be 6 ayes and no nays. Committee substitute Senate Bill 957 will be, or, excuse me, which one is this?
863.
836, be reported to the full Senate with a favorable recommendation. Senator King moves to move this bill to recommend for local and uncontested calendar. Is anybody, any objection? Hearing none. So ordered. Next bill up. Okay. This is substitute.
That's right.
None? The chair calls up Senate Bill 906. Members, that Senate Bill 906 be adopted. The recommendation do pass and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 6 ayes.
Be 6 ayes and 0 nays. Senate Bill 906 is reported favorably to the full Senate. Senator Miles recommends that Senate Bill 906 be recommended local and uncontested calendar. Any objection? Hearing none, so granted. Chair calls up Senate Bill 993. Senator Parker moves that Senate Bill 993 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 6 ayes.
That'd be 6 ayes and 0 nays. Senate Bill 993 will be reported to the full Senate with a favorable recommendation. Senator Hinojosa recommends that Senate Bill 993 be recommended for local and uncontested calendar. Is there any objection? Hearing none, so granted. Yes, Senator Miles.
I recommend you call 860 back.
Which one, Senator Miles?
860.
Which one?
860. Your bill, Mr. Chairman. your bill.
860? Oh, yes. You want me to, I can't call my own bill.
Okay, we're gonna put it in writing for you. You can take it to local. He can call it.
Chairman, can I recall Senate Bill 860 to come back before the committee to reconsider the vote by which
Yes.
was passed?
Yes.
Yeah, that's-
So we now have Senate Bill 860 in front of us. I guess Senator Miles?
Aye. He can take it local. He can take the local.
Okay. Are you changing your vote?
Yeah, yes, sir.
Senator Miles wishes to change his vote on Senate Bill 860 from nay to aye. Is there any objection? Chair is none, so ordered. At this time, Senator Miles recommends Senate Bill 860 for local. Is there any objection to that? It
That
is
was a long time.
it is not, it's so ordered.
Thank you. Thank you, Senator Miles. Okay, where are we at? Senator Parker moves that Senate Bill 1321 be reported to the full Senate with a recommendation that do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles,
Aye.
Senator King, Senator Hagenbu. 6 ayes, no nays.
Being 6 ayes and no nays, Senate Bill 1321 will be reported to the full Senate with a favorable recommendation. Senator Hinojosa recommends that Senate Bill 1321 be recommended for local and uncontested calendar. Is there any objection? Hearing none, so granted. 1379. 1370 or 1370? Senator Hagenbooth moves that Senate Bill 1370 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman. Senator Miles.
Aye.
Senator King. Senator Hagenbu. 6 ayes, no
There be
nays.
6 ayes and 0 nays. Senate Bill 1370 will be reported to the full Senate with a favorable recommendation. So Senator Hinojosa recommends that Senate Bill 1370 be recommended for the local and uncontested calendar. Is there objection? Hearing none, so granted. Fifteen 37. Where is 1537? Go here. We didn't adopt. We adopted. Which bill is that? 1537. Member Senator Hinojosa moves that Senate Bill 1337 do not pass, but that the committee substitute adopted in lieu of do pass and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman. Senator Miles.
Aye.
Senator King. Senator Hagenbu. 6 ayes.
There be 6 ayes and 0 nays. Committee substitute 1537 will be reported to the full Senate with a favorable recommendation. Senator Parker moves that Committee substitute Senate Bill 1370 be recommended for local and uncontested calendar. Any objection? Hearing none, so granted.
1537.
Now we'll move on to Senator Menendez's bill. He was smiling about that today. So, Senator Hinojosa moves that Senate Bill 1563 be reported to the full Senate with a recommendation that do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman. Senator Miles.
Aye.
Senator King. Senator Hagenbu. 6 ayes, no
There be
nays.
6 ayes, 0 nays. Senate Bill 1563 will be reported to the full Senate with a favorable recommendation. Senator Miles recommends that Senate Bill 1563 be recommended for local and uncontested calendar. Any objection? Hearing none. So granted. Yes. 1537. You called. She just called. So you know that. Yes, sir. We're going to make sure we correct that. It's back up to what number? 1537.
Chairman, I'd like to have recall Senate Bill 1537 as substituted.
Yes. So granted.
All right, so we have back Senate Bill 1537. Was it a substitute on that?
Yes.
As substituted. Senator Miles moved that Senate Bill 1537 be reported to the Senate with a recommendation do not pass, but in lieu thereof, that Senate Bill 1537 as substituted be passed and recommended for a favorable consideration of the Senate. Clerk call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 6 ayes, no nays.
There being 6 ayes, no nays, Senate Bill 1537 as substituted is recommended and passed on to the Senate with a favorable recommendation.
Good. Do we do local for that one?
Is there any objection?
Yep.
Recommendation for local, the chair has none, it's so ordered.
Thank you, Senator Miles. That's what a good team is all about. Can't keep me straight on these numbers. Chair brings out Senate Bill 1610. The chair moves that Senate Bill 1610 do not pass, but that the committee substitute for Senate Bill 1610 be adopted in lieu of their do pass and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa, Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. Six ayes.
There be 6 ayes and 0 nays. Committee substitute for Senate Bill 1610 will be reported to the full Senate with a favorable recommendation. Senator Parker moves that the committee substitute for Senate Bill 1610 be recommended for local and uncontested calendar. Any objection? Hearing none, so granted. Well, members, that we have 2 bills pending, and we'll be working on them, and thank you, Senator King, for that, and Senator Miles, Senator Hinojosa, thank you for that input and robust discussion. And so, with that, the committee stands at recess, subject to the call of the chair.